Yes. 40?
42 and 45.
2 and 45, yes.
Can you be accommodated on part of one person?
3rd of June, we don't know. 42. 45. At the request of the learned counsel for the petitioner. You have informed the department.
Yes, of course.
Not objected to by the learned counsel for the respondents. List this matter again on 40,
42 and 45.
42 and 45. 3rd of June. 3rd of June. Duta beleg heri ha. Petition duta beleg connected no hoy. Yes. Yes, madam.
Your Lordship, with the consent of the other side, I would like to mention item 83.
Yes.
Your Lordship, we need to file the affidavit in opposition. Your Lordship may fix it after 2 weeks.
Have you informed the counsel for the petitioner?
Yes, Lordship.
At the request of the learned counsel for the respondent, not objected to by the learned counsel for the petitioner, place this matter again after 2 weeks of the 10th of June.
82.
Yes.
Item number 19 and 29.
19 and 20. The request of the learned counsel appearing for the, you are appearing for the petitioner, list this matter again. You have after a week.
May I please, Your Lordship? I beg to mention item number 37, my lord. It's a bail hearing, my lord. May I pray for accommodation in any other day, my lord? TCR is called for, perhaps TCR is not available, maybe, my lord. Or it's not shown in the cause list, my lord.
At the request of the learned counsel for the petitioner, list this matter again on.
It's from Gauhati, my lord.
5th.
5th. Highly obliged.
May it please the Lordship?
Yes.
Lordship, may I please beg to mention item 85 on the supplementary list.
Uh,
Also, Your Lordship, by order, it is 6th of April, and including prayer was allowed. May I please beg to let
For
the,
item number 85,
yes, Your Lordship.
it is by order.
Actually, we had listed it for the interim prayer, but because of heat, my knowledge, the council is not available today. So may I please pray to let the matter be ordered in the other
Why
day.
is he not here on, we have given the facility of a VC.
Actually, he is a little occupied with, I'm so sorry for that, Your Lordship.
At the request of the learned counsel for the petitioner, list this matter again. Second report. 9, 10, 8. What? Huh? 19. 19th of June. Interim order passed earlier shall continue. Have you informed the other side?
Yes, Your
Yes,
Lordship.
I'm for the respondent.
Okay. Ms. So-and-so appears for the respondents. Your name?
L Izu.
L. Yezu.
L Izu.
Yes.
May I praise your lordship? With your lordship permission, I like to go to the office note of item number 40. Okay.
Yes. Admission column. Okay. Budhwar review on Wednesday next. Give the date of your. Yes.
45 will also for order.
Hmm.
Madam, we adjourn for that day.
Huh?
Adjourn for the day came up on Wednesday next.
45 already mentioned. In the
Mentioned.
morning.
Sorry, sir.
Five. Yes.
Can it be taken up at 2 p.m.?
Okay. At 2 Mati to go 5. Yes. Next Friday? Give the date of next Friday.
My lord, I beg to mention item number 81 supplementary.
81.
Yes. I have to file reply. Objection has been filed. I have to file my lord rejoinder.
At the request of the learned counsel paying for the petitioner. Well, list this matter again on when?
1, 2 weeks, my lord.
2 weeks. 18th of June.
Obliged.
Yes.
Which by that,
Hmm.
Lordship, it was listed 2 days back, but On the location, Lordship has directed police the matter for the suspect bench. But it has been inadvertently it has been listed again, Lordship. Finally, Lordship may fix the matter next week, Lordship, since there is some urgency.
Please the matter again on. Iman. সোমবার মঙ্গলবার huh? On 3rd of June.
Yes, Lordship.
Yes. Three six.
56. 56.
36.
36. 36.
Bail hearing.
Oh, motion at us. Yes.
36 Lordship, TCR notice.
36 TC.
56.
Court master. This is item 56.
56.
Okay, we'll take up 56 first. Yes. Hmm.
Sir, second bill application, their lordship is to reject the bill application of third parallel of the city. Now, this application was filed absolutely on on medical ground. No, we are not, she will not consider the merit. And they
Okay.
have rejected my bill application on merit. But you will find page 18, lordship. My father is a cancer patient.
Hmm.
He's undergoing chemotherapy as well as radiotherapy also. And almost dead bed. Now, as per his desire, he was released from the hospital because he wants to be the family member in his last days. Now, I am the only son. I want to be beside him. So any condition, lordship, because already lordship has.
What was the allegation?
Allegation that from on receipt of a secret information, 62 point some kg was ganja was required from a abandoned car. Subsequently, it was found that car, registered number owner has an agreement with me. So there is a suspicion. I was not arrested from the spot. Nothing has been recovered from me. Subsequently, it was.
When were you arrested?
No, I'm
Not arrested.
for 13.
This anticipatory bill was rejected.
My earlier petition was rejected. After.
We'll ask him to appear within 7 days.
Absolutely not, Lordship. I have no objection, Lordship. On
Huh.
3 counts, first, Lordship, the whole premise that not on merit, that cannot be considered by Lordship because this is a commercial quantity case. Section 37 has to be satisfied by your Lordship. Without that, a bail in a commercial quantity cannot be granted. More so of the fact, Lordship, because this is an anticipatory bail, finding material Lordship has rejected. Second submission is, Lordship, the father of the petitioner is undergoing treatment. I have one instance in my possession, Lordship, where the accused, he himself was suffering from HIV, his bail was rejected by the Supreme Court. That is my second submission, Lordship. At this stage, Lordship, at the most, CD can be considered. But if he is not placing on merits, then it needs to be rejected right now, Lordship. Because bail under NDPS commercial without satisfaction of 37 cannot be granted, Lordship. Absolutely not. And more so because, Lordship, this is AB.
No, see, till the time he is on the run,
Lordship,
you would not have any information.
Lordship.
The position is such that the father being on the deathbed, media visit, and further materials on the CD, you still have the option of rejecting it totally.
Lordship,
But your investigation, would it proceed without his presence? Granting him the opportunity to appear before you would give you a headway somewhere. The moment more materials come up, you can have him back.
Lordship, materials are already there, Lordship. The Lordship had rejected it on 10, 16/3/26, finding materials, Lordship.
And Lordship, my respectful submission, Lordship, commercial quantity without satisfaction of 37,
Not from my physical possession.
that is not the issue here, Lordship.
So I am not doing it.
Lordship, no, without going to
Any
merits,
condition
Lordship,
like
bail cannot be
If
considered.
necessary, I will report the police twice in a week. That
No,
will,
we are not granting you a bail today, sir. We are 2 stages before that. Whether we can allow you to appear before the police, visit your father, and then perhaps
And Lordship,
back to the pavilion.
there are instances of the observation of Supreme Court where it is stated that AB in a commercial quantity case is unheard of. I have the judgment also, Lordship, that it is unheard of. Unheard of, Lordship. Cannot be, Lordship. It's a very serious issue, Lordship. AB.
And when was it last rejected?
16/3/25.
16, some updation would be there in the CD?
Yes, and I'm
Hopefully.
not sure, Lordship, what is the stage of the investigation.
Now,
There is
we'll have it on
charge
when?
sheet. As your Lordship directs. From
Huh?
Dima, Udalguri, Lordship, Dima.
can it be on 5th
5th,
of June?
5th of June, sir?
Lordship.
Hmm?
Lordship.
On the 5th of June.
Lordship.
Had Mr. So-and-so and counsel appearing for the petition. Also had Mr. Somal and counsel appearing for the learned APP. Call for the updated case diary. List again on the 5th of June.
8. Possible, Lordship.
Every day counts for him. The situation,
Lordship.
every day counts.
Lordship.
Huh? 5th.
Difference.
36, Lordship, there is a office note which states that TCR has not been received. 25/5/26. TCR, Hani.
TCR is not available. Hmm? How many days? What is your,
Abatement to suicide, my lordship,
can it be only?
Cannot be.
Abatement to suicide, my
Huh? Where is the FIR?
Where is on page 14, my lordship, and the charge sheet is on page 32, my lordship. After the investigation.
Page 26.
Office note reflects that the TCR is not yet received. The same was called for on 18/5/2026, issue reminder, list again on the 5th of June. 5th of June.
Highly obliged.
Dear Lordship, this is a POCSO case. Steps was taken on 20 of this month and report has not been received. No, Lordship, we have to wait, Lordship. Matters cannot be accounted in this manner. Lordship. Steps were taken on only on 28th. There is a office note, Lordship.
Why this wrong translation? At page 12. We do not need the FIR to be read out. Kindly read your FIR in the vernacular and kindly read your FIR in the translated version. Insertion becomes pointed.
Yes.
We do not appreciate this. Lord counsel for the petitioner shall file an additional affidavit containing a correct translation of the FIR. List again on the 5th of June, 2026.
Here also, Lordship, the service report is awaited. Steps were taken on 20.
What is the age of the petitioners? Where is the FIR?
FIR is a page 14, well.
Wait, the DCR is here. DCR is here. We'll appoint an amicus. Fix it on the next date. Awaiting service report on the respondent number 2, who shall be allowed to be represented if she engages a counsel. At least one step ahead. The TCR call for has been received. Come on. The matter relates to allegations under the POCSO Act. Accordingly, this court deems it fit to appoint. Did you? Did you? Srimati Preeti Das as the amicus in the matter. It's learned counsel for the petitioner shall supply a copy of the bail petition to the learned amicus. Full stop. List again on the 5th of June, 2026. Full stop. In the event the respondent number 2 enters appearance to a counsel from the same shall also be allowed. Petition. 43. None appears for the petitioner on call. List again on 8th of June. Interim assembly.
Mullah.
8th of June. কোনটো? অলপ পিছত নহলে বাকী চব পিছে পিছে কোন আছে কোন আছে কাউন্সিল কোন আছে ইফালে Mr. Gautam, we can do one thing. We'll take up the list. If you start delivering order, we have only till 3:15 today. We'll try to finish as many as possible. If there is time, Mr. Konik is here. We'll take up the other cases first. Otherwise, people will have to keep waiting. If there is time, we'll deliver the orders today.
Might not be dictating this.
At 3, but we have to rise at 3:50.
Yes.
If not today, on Monday.
Well,
Yes?
if sometime cannot be watching accommodate.
But we are not.
Lordship, I am appearing for respondent of 5 and 6.
Ah.
Lordship, I am submitting a written submission.
Please.
Lordship. Yes.
What we have said is, if it deliver the order now, others will keep waiting.
Yes, Lordship.
We'll try to take it up at the end of the board or on Monday. You give that argument. Give the arguments. No problem.
Written submission.
You get next to- you. Where is the order? Page 9. Eh? Where is the detailed representation? Your name? Heard. Mr. So-and-so, a counsel paying for the petitioner, issue notice, steps by speed post within 3 days from today, within 3 working days.
Okay.
List again on 17th of July, 2026 with service support.
Okay. If we.
Yes, sir.
Party for
Huh?
space creative payment.
Operative portion.
Yes. Paragraph.
Press representation file.
My lord 24, please.
Heard Mr. So-and-so, a counsel paying for the petitioner.
Yes.
Issue notice, issue notice by speed post, steps within 3 working days, list on the 18th of June, 18th of July. No, 17th of July.
Public.
18th July. Yes, madam.
Please, Your Lordship. This is regarding family pension loss. Lordship, may kindly see last order of this honorable court, 27th. A partial with this order, Lordship, we have submitted life certificate before the treasury, Lordship. But we did nothing. 2018,
You were receiving the pension. You did not receive anything.
this is pension lordship. Page number 23 of my petition, last page of my petition. Lordship.
The PPO is there, treasury officer is there.
Lordship,
Why is he returning the PPO?
some discrepancies were there, your lordship.
If I can just have the letter, Lordship, Lordship, it was cancelled by the director of pension only as per the letter.
12th of May, it has gone to your,
12th of May, Lordship, yes.
it has gone to you.
Yes, Lordship, now as per that, I can.
We'll
get
have
my-
it, we'll have it
Wednesday,
on
Lordship.
the 15th of June.
Lordship, Lordship.
Learner Council is paying for the finance department has submitted.
Lordship, I can I keep a copy?
Yeah, yes, yes. Hi. Ms. Fukon, the Learner Council is paying for the director of pension. You are paying for pension? Director of pension has submitted that a fresh PPO has been forwarded to the treasury officer, Borpeta on the 12th of May, 2026. Full stop. Learned, Mr. H. Olihal and the council is paying for the finance department has sought for an accommodation to find out the status of payment of the family pension to the petitioner. Full stop. Accordingly, release the matter again on the 15th of June
Lordship.
for an updated status.
Yes, sir.
Full stop. The letter dated 12th May 2026 is kept as a part of records by marking the same as X. Mr. V. Sharma, Learned Council appears for the accounting general. Fresh PPO has been issued for family pension. Can process the regular family pension.
Yes, Lord, that now I think, Lordship, it will be done because the PPO has been.
Yes, it will do. Why this big written submission?
Item
WPC number, sir. Yes,
677, can you pass over the matter from the time when?
no passwords. You'll have it in June then.
Can you cancel?
Either tell us what is it? Tell us what is it? Arrear salary.
Arrear
But
salary.
Mr. Swan, Learner Council is paying for the petition.
Amount is different.
The petitioner has paid for payment of arrear salary for a certain period. Full stop. Issue notice. You appear for all the respondents, madam?
I am appearing for 2, 3 and 4.
Ms. Swenson appears for the respondent number 2, 3, and 4. Mr. Bopujari for respondent number 1. And any more?
Nice.
Full stop. Since the respondents are represented, formal steps not called for. Full stop. However, petition counsel for petitioners will serve extra copies upon the counsel for the respondents within a period of 3 days, 3 working days. Full stop. List again on 24th of June, 2026, allowing the respondents to have their instructions and or to file requisite affidavits in the matter.
Deeply organized.
Same already. They have to give their stand before we. Yes. Affidavit filed, sir?
Lordship, fine.
89204. What is the matter about?
Lordship, Lordship, with regard to the inquiry report, Lordship, that's annexure 10. That paid for setting aside of the inquiry report. At page 37.
What is your stand?
Lordship, our affidavit, Lordship, starts from page 39.
Just tell us what is the stand. Have you read it? No.
Lordship,
Have you read your stand?
Lordship,
Do you know what is your stand? The affidavit in opposition has been filed by the respondent authorities on 89202 full stop, none appears for the petitioner today, full stop. List the matter again on the 22nd of June, allowing the petitioners to be represented. Yes, sir.
My lord. My lord, this matter relates to an impugn order issued by the additional deputy commissioner of Ujai. My lord, may I just for a moment, I beg to draw is at page 49. Page 49, Lord, whereas a public complaint petition dated 26/2/2026 has been received from Afzal Hussain Laskar and two others of so and so. Alleged fraudulent issuance of EU dice code number so and so in respect of the United English School Velguri cluster under the Jogitan Education Block. And whereas period the FIR filed by the Inspector of School HBC Hudai, filed letter number dated United English School Velguri Hudai Assam. Whereas it is observed that the Inspector of Schools cum District Elementary Education Officer Hudai NPC in report the white letter number dated so and so stated that he had received a report from the Director of Secondary Education Assam, wherein it was stated that no EU-DICE code was issued in the name of the United English School Velguri from the said office. The related file was opened and processed in the name of so and so under 8DC. Hence, the EU-DICE code used by the United English School Velguri was fake, and the said institution was running illegal. On examining the above matter and after careful consideration of the report submitted by the Inspector of Schools from District Elementary Education Officer Hudai along with the report of the so and so, they undersigned direct the Inspector of Schools from District Elementary Education Officer Hudai to take necessary action for sealing and closure of the above mentioned school. The Inspector of Schools from District Elementary Education Officer Hudai will submit a compliance report to the undersigned within 3 working days. Further, the Inspector of School of so and so shall take necessary steps to accommodate the existing students of the United English School so and so in the nearby educational institutes. So now, my lord, now from perusal of this order, my lord, it appears that the allegation is that we are using a fake dice code which has been appears to be opened in the name of my lord Kapoha Adarsha Jatiya Vidyalaya. Now, my lordship is well aware, my lord, they are maintaining a website. And in that website, my lord, if at this moment, my lord, if we check the official website, and screenshot, my lord, we have provided, my lord, may I?
Who appears for the Samagra Shiksha Vision?
My lord, Mr. S. Bora, I have informed him also, my lord, Santanu Bora. So, my lord, can it be taken up after some time, my lord?
Are you appearing, madam?
No, Lordship, Mr. Esbor is on legs in port number 1, Lordship.
After some time. Some urgency is there because of 246 numbers of students, my lord.
Do you have the permission?
Yes, my lord, all,
Permission
there.
from the government, everything?
My lord, those are not. been
Non-government,
objected.
oh, without them, how can you have a UDAS?
My lord, may kindly see the speaking order, which by which. they have
We'll all see that, we'll all see that,
My lord.
whether you are a school which has the permission to run.
Yes, that is not the objection raised by them, my lord. They have verified all records and documents also, my lord. That's why,
Have him,
my lord,
after some time, you will.
my lord. All right.
Yes, madam?
As for the, I think, 37, 38 election G manner. The petitioner has been transferred from Assam Engineering College to Bilaspur Government Engineering College.
Hmm.
Kokrajhar.
Huh?
So, my lord, here the ground of challenge is, firstly, he has not yet been released till date, and so he is still working here. And secondly, my lord, now he has been made the chairman of the Board of Studies, my lord. This is annexure J at 8, my lord. 42, my lord. For 3 years, my lord. This is dated 17 June 2025.
Hmm.
And here I would say the board chairman is the petitioner for 1 member. Page 42. This board is constituted, the Board of Studies will scrutinize and suggest proper content of syllabus of UG and PG courses in instrumentation engineering. And here, like above, viewers is effective for a period of 3 years from the date of issue of award. So he has to be here, Maya, and moreover, Maya, he is going to retire on 30th June 2027. Tag under this service career, Maya. Moreover, 2 posts of professor of instrumentation engineering as well as electrical engineering are still lying vacant in the Assam Engineering College.
Where is the transfer order?
Page 37, annexure G.
But it is on promotion, forgo the promotion,
Yes, madam. Okay.
forgo the promotion.
But there is post available, madam, there, madam, at Gauhati.
क्या हायर एजुकेशन फर्स्ट विषय दिया ना नहीं हायर एजुकेशन
Pending.
फर्स्ट विषय हायर एजुकेशन दिया ना नहीं दिस है item 59 नहीं record higher education running at the video scroll the video after some time madam let someone from higher education be here he will possibly he asked you to he's standing consider for us to and also for higher education so he go yes
The petitioner before your notice on students of the way Jadunath College.
Ah.
Their 4th year examination, which they have cleared, were declared to be null and void.
Ah.
Because they didn't have the gap, 6 months gap between their 3rd year examination and their 4th year examination. Now, a group of students came before the court matter, and the court granted
Yes.
relief in the interim matter, saying that their internship should not be stopped,
Yes,
which they were continuing. Now, the petitioners before your lordship, these two have not yet started their internship. Last Monday, similar group, another similar group came. There also a relief was granted saying that those who have not started their internship should not be made to appear in the pre-exam form. They have discussed.
Yes, Lordship. Well,
Same order?
Yes, same order.
Heard Mr. So-and-so learned counsel, Mr. P. Bhardwaj learned counsel paying for the petitioner. Also heard Mr. H. Oliha learned counsel paying for the learned
Health
pending
department.
counsel, health. Full stop. The learned counsel for the petitioner has submitted that similar petitions based on similar circumstances. One of them being WPC 2722 of 2026 have already been, are already pending before this court, where by the order dated 25/5/2026, notices were issued upon the respondents and an interim relief had also been granted to the petitioners therein, full stop. At the prayer of the learned counsel paying for the parties, list this petition along with WPC number 2733 of 2026, full stop. The interim protection granted to the petitioners in WPC 2733 of 2026 shall also apply to the present petitioners. Issue notice. All the respondents are present all.
No, Lordship.
Who else?
So I'll be appearing for 1, 2, 5, 6, let's say.
Mr. Tiliha appears for the respondent number 1, 2, 5, and 6. Full stop. No formal steps are followed for the state respondents since they are presented. Extra copies to be served upon the council appearing within a period of 3 working days from today. Steps by speed post from the other respondents within a period of 3 working days. No, but he did the same. Oh, yes. Subsequently, the government decided to cancel their appointment. The long series of litigation, the court finally had a
একটু ফাইল কোনে চেক করিস ফাইল কেনাকে পাস হবে পেজ 37 পেজ 39 পেজ 38
page 281.
ফাইলিং your page running chart page 37 thereafter we have page 37 then we have page 39 then we have page 38 annexure
37, page 281.
Yes.
In case of a similar place petitioner's note,
Ah.
court was pleased to allow the petitioner note, but the court will deal with the need service. So I'm praying for a notice to this matter. And a similar matter, place of copy of the order note, please complete.
It's fixed on third of this month.
Third of this month,
Third of next month.
3rd of June.
Third of June.
Who appears for the deputy commissioner, district commissioner,
District Commissioner.
district commissioner here? Third. The learned counsel for the petitioner also heard Mr. P. Possible learned counsel appearing for the respondent number 1, 2, and 3. It's
1, 2, 3, and 4. 1, 2, 3, and 4.
1, 2, 3, and 4. Mr. Ansel for the respondent number 5. Instead of issuing notice, returnable on the 3rd of June. Since all the respondents are represented, no comments were called for extra copies on or before the 1st of June 2026. Instead, the learned counsel for the petition has submitted that with petitions on similar circumstances are pending before this court, one of them being WPC number 244432026 and it's paid for the matters to be listed together. Indeed. With the consent of the learned counsel appearing for the respondents, with which matter along with WPC number 244432026, which is stated to be fixed for listing on 3/6/2026. Yes, ma'am.
Regarding selection for a I don't. But in March, earlier he was selected. Not selected, he was appointed.
In charge. Ah. The respondent was initially appointed as the principal.
What has happened?
There was a writ petition.
Petition
They
challenging.
were asked to reconduct the selection process.
The selection.
In the meantime, he remained the in charge.
In charge.
Reselection took place. Then what happened?
Then I got selected, your lordship.
Okay.
Now her case is that, your lordship, the marks.
Yes.
Guidelines, we will have not much more. Guideline is that
42. Hmm.
The one for each year of the subject. Maximum 3 months.
Yeah.
Okay. One much of the year of it. 6 months. Permission is 1 year has been completed.
He has been given,
1 month.
wait,
Yes, but
page 49 years. He has got a total of 4 marks.
4 months by the time.
You got 3,
Yes.
he got 4. Why?
For experience, since he has not completed 1 year as itself principal, he cannot be allowed them. One. If below 1 year, will not be. How it will be calculated, because this can be for. That's something. Colin again. That if you see spirit, that's it's not Colin again. That divided. Thereafter again. It's that
From 4th of September onwards, who was the in charge?
earlier he was in charge, but when he said he was reverted back as something.
He was the principal. He was reverted back. Who was appointed as the principal? In charge.
In charge.
For that, after 4/9/2019,
I was appointed.
where is that appointment letter? For as in charge? Yeah. Madam, please have page 35. Please have page 35. You have responded to this? Have you responded to this? Yes. It is from, who has issued it? At the top? Then you responded to it, you did not object to it. You considered him to be an in charge principal.
Because I have this, because
Where?
it's not completed 1 year.
Ah,
Uh,
when was he promoted?
Lordship, initially, your lordship, my promotion is your lordship,
Huh?
that is your lordship. 31/1/2018, I was appointed your lordship, as a principal.
31/1/2018.
I was appointed as principal.
And you were removed on?
On 12/3/2019, when the order was passed by the.
No, you were removed on
12,
4/9.
no, your lordship 4/9, but your lordship, honorable court's order is directed at, passed at 12/3/2019,
Just a minute.
page 29.
You were appointed when?
I am appointed.
31/1/2018.
31/1/2018, lordship. On 12/3/2019, judgment by the Honorable Justice Ujjwal Bhuiya, your lordship, by which your lordship court held that my appointment was not correct and fresh election is to be held. Now, court also allows me to continue as principal in charge. Now, what continue is there? Now, the case of the petitioner is that, your lordship, the experience I have gathered as principal in charge will have to be considered not from earlier when I have been appointed as initially as a principal, but from the date, subsequent date when I was made principal in charge.
When were you made the principal in charge on an earlier date?
No, your lordship, earlier date, this is a regular principal.
Appointed on 31/1/2018.
Lordship.
Okay.
Now, your lordship, in the meanwhile, some development has also taken place. My friend's client have already been appointed as the principal in some other school, your lordship. And he has joined and continuing as a principal and that.
He wants it here.
That I don't know whether he will.
Yes, madam, what do you say? Join somewhere else? Litigation needs to be continued. No, no, if you have joined somewhere else, does your client want to continue with this litigation?
I have want to be done. First, once it is illegal, it's illegal. Whether he is appointed or not, it will declare, it says that illegally somebody has been holding the post and entering the post, the benefit of the post.
So now it becomes,
Lordship can hear that. Otherwise, your lordship, as a principal, my experience will be, your lordship, 2 years, 1 month.
From
From the date of holding of the charge as a principal for the till your lordship, interview, the interview was held, your lordship.
when was the interview?
Advertisement, your lordship, advertisement is dated 12/9/2019. Till that date, your lordship, it is around 2 years, your lordship.
Yes, madam, anything else?
And in fact, your lordship,
2018 to. Okay,
now your lordship, only
we have come to.
lords.
Yes, madam. Please continue. Mm.
Thereafter, the department has reverted to the subject. But this particular reverted to subject. Mention in the this particular order also. The director, education, with this is the first step, the place selection to that, was the principal, with that, the line of guidance. Year by 2019, selection was held. So that's good. Fourth March 23. There is not much gap time. September, 3rd September. 3rd September 19, and my selection is then 4th of March 23. So September to March. So he has not completed around 6 months, around 6 months, not 1 year. As required as part of the you know, I think up to the office for this particular. Last one of the time of the experience for 1 year, 1 year for CRO experience. But experiences in such principle. The government has to be counted from the date of census principle. The date of selection, it has to come 1 year, one month. But yes, since of the date of the census principle, he has not completed final 1 year. Whereas by the deadline, by the deadline of this woman, that is not completed for this extra 1 month. That is, but if you are showing response number 5, then you're also 5. I think the 5 again. But we take the period I have shown. Because the scale is also. And 2008, with the school number 5 was, I continue to regular principal and provide down. Not support this one. Because Friday, earlier.
It is not here. Who appears for the DTC? Do you have the letter dated 4/9/2019? By which he was reverted?
Submitted by them.
Inspector of school, who appears? Who appears for the IS education
The
department?
person your lordship will get it at page 33. Order. 33,
No, page 33 is communicating that order,
lordship.
that you were reverted by order dated so and so.
Lord,
Kindly at page 34.
lordship,
At page 34, they refer to another letter of 4th of September.
lordship. That they have produced on earlier occasion, your lordship, and handed over to the. Okay,
What is your stand on the, Madam Saikia? What is your stand on the allegation that your ACR reports were fake?
That has not been given. Number.
You produced it before the selection committee, did you not? ACRs have to be produced before the selection committee.
This year is it's not.
So the superior has to come with the superior officer has to come with the ACR report for every candidate to every selection center.
The school itself, or in the district. We have must be principal with the president of the estate. And what is reported, I have given in my planning.
You have not given any reply to that.
Reply to the benefit.
Yes. Where have you stated it is not in your custody and that they are not false or thing? Huh?
Page 83.
83 years. Hmm, 83.
The selection board.
Madam, if you want, we'll take it up at 2 o'clock. Find me that paragraph where you have said that, yes, the ACR is not wrong. Your statement. I have read every paragraph. I have read every affidavit and reply filed by you. I have gone through every affidavit and reply, madam. Huh? I will have it after some time then. Come back at 2. Really accommodate us, madam, we have got around 98 cases to pick up. You're searching here in the court, it's killing time.
Yes, asking some. Lordship, my case is very simple. Our case is that, your lordship, the experience I've gathered before my reversal will automatically obligate to do. My submissions that cannot be made. Whether my appointment was correct or not, it's a different matter. Experience I gathered as a principal, where will it that go, your lordship? Ultimately, the issue is, your lordship, the experience as a principal, your lordship. Now the court, your lordship, if honorable court, your lordship, order, your lordship looks at, it's a very use the term.
You were a senior most,
Lordship, lordship,
you were also qualified.
lordship, no issues about that. Only issue whether I am entitled to that 1 mark or not, your lordship. According to her, your lordship, her client, your lordship, I should, my experience should be counted from the date of reversion, your lordship, or the date of order of the honorable court, your lordship. In that case, it will come around 6 months, your lordship. And my case is that, and that has been award marks has been awarded on that basis, your lordship, that, your lordship, that my experience as a principal, which I have gathered, that cannot get obliterated, your lordship, and therefore your lordship will kindly see this order at page 32. It's very, the honorable court has used the word continue, your lordship. By using that word continue, your lordship, it has linked my earlier holding of post as a principal to the subsequent principal.
Have you been appointed?
Lordship?
Have you been appointed?
Yes, your lordship.
And you are holding the post of
Post,
regular principal now?
regular principal,
There is no interim order.
no interim order. I have been holding the post, and that is why, your lordship, and only two judgment on that aspect, your lordship, I want to place one Supreme Court judgment, your lordship. Here the issue was, your lordship, it's annoying. Lordship, here, your lordship, issue was, your lordship, a person was appointed in a clerical post, which was not a sanctioned post, your lordship.
Okay.
Whether his experience will be counted or not. That was the
But he
issue.
worked as a clerk, so it was counted. Something like
Counted,
that.
your lordship. That's what has been held by the honorable court. Your lordship will first paragraph 6(2). Since the first respondent was engaged in the university by the service provider Lavanya under the outsourcing policy for the requirement of the office organ not appointed on any regular or sanctioned post of clerk, the experience acquired by her cannot be equated with the experience working on a sanctioned post of clerk. Now, honorable court of para 20 has held that it will have to be, your lordship. Ultimately, he has gathered the experience, and what experience means, your lordship, on that, your lordship, for my
Which paragraph did you say?
para 20, your lordship,
20.
20. Your lordship, para 20, taking a cue from the aforesaid decision or observation is this, it cannot be gainsaid that even though the modalities for engagement of two individuals for executing similar nature of work could differ. There can be no quarrel that none can gain experience without being asked to work. One vital difference is in working on a sanctioned post as a permanent employee and being employed in the agency of administration without having a right to post is that in the former, the appointees enjoys procedural safeguards, bringing in a sense of security service in him, while the latter, the individual concerns may not have any sense of security. But in case both perform the work of clerks, the experience gained would not be much at variance. And your lordship,
Yes.
this judgment, your lordship, from Jammu and Kashmir High Court, your lordship, on what experience means, your lordship. Para 5, your lordship. May I read, your lordship? Here the advertisement notices uses the term experience as noun. The term experience of teaching is not defined anywhere. However, the ordinary dictionary meaning of experience is the knowledge or skill resulted from practical acquaintance with facts and actual observations of events. Black's Law Dictionary 6th edition gives out the meaning of experience as a state, extent, or duration of being engaged in a particular study or work. The real life is contrasted with the ideal or imaginary. In common parlance, experience means knowledge or wisdom gained by working on a certain post. The knowledge, besides other factors, can be gained by observation and interaction. Experience implies skill and knowledge gained by personal knowledge, feeling, or action. The term brings into its fold wisdom gained out of a person's instinctive faculties rather than by reason. It is also signifies learning by doing apart from receiving such learning through the agencies of idealism or imagination. That experience I already gathered as a principal, your lordship. Where will it go, your lordship? It will be too technical, your lordship, approach if we interpret it in that manner. And finally, your lordship, rightly or wrongly, there is a finding by the inspector of schools that her the ACRs, your lordship, are not correct. There is some discrepancies in the ACR that has been part of the letter, is part of the annexed by the respondent number 3, your lordship, page 80 of the running page, your lordship.
Yes.
This letter, your lordship, it may be right, it may be wrong, but until and unless this is put to challenge, your lordship, it stands, it holds the field, your lordship. It's staring at her face, your lordship. Petitioner's face, your lordship. Unless it goes, your lordship, and the ground on which he was not appointed, your lordship, is that his ACR is not correct. And for holding that, they have relied on a letter from the inspector of schools. This letter has never been challenged, your lordship. Therefore, until and unless this is put to challenge, your lordship, this will stay, your lordship. It's holding the field. And it is staring at the face of the petitioner, your lordship. Therefore, your lordship, writ petition is, your lordship, liable to be dismissed. And in view of the fact that he has already been accommodated in another school, your lordship, has got what his due for.
Whether selection overlook the guidelines of the student. Number one. Number two, when we regarded them, the reversion, although it is a bunch of paper computer system. Now I can put that is here. Sorry, that
No.
113 will come back. Why? The confidential witnesses in the government's every
Madam, if we read the whole rule now, it will become very difficult for us. We are running short on time.
Yes, to be given by a total. Because it is in the customer certificate. That is not that I, that I report, good pilot, I myself, company give me my. So I don't, it was a hard. In this connection, I was never been given anything that something. We need to get. Whatever it is, but instead they have collected the money. And my superior, sorry. We also the contested of the interview. So that will be biased. Charity inspectors has to be not really or any sort of verification, only that voting, only in the selection committee, selection will be biased, because earlier also negative was appointed. Voters compelled to set aside a vote. Second time again, they have used their bias and kind of some they have appointed selected people. So if they are biased, it's a different thing. I've given a short kind of after the getting that scale. Scale is different, like the subject is a scale. Whether he has completed the itself and purchase scale for 1 year. This is very somewhat about the right to the our that's right. Yeah, that's the stuff we do. That's but we passed that by appointed. But in my case, since we have been appointed member, the appointment not for at the junction, but that's the comprehension. That's like and allowed. I'll be satisfied if I make his appointment for the ground government. Not to do one more. Or to be not to take 1 year. Appointment. And I don't. I should be given seniority of that. So there is no post, but get another thing. And that's to be affected in my. And find out.
Have you brought to the notice of this
I have
court
to-
that you were appointed somewhere else?
Somebody.
Have you brought it to the notice of this court?
Europa has it.
Have you brought it to the notice of the court? We don't know on record.
Yes. On record, my not after that, this are I have not filed it. Because my not the thing and not hearing, but I was not having in my that was done for because I was reading.
Anything else, madam, we need to consider? Anything else we would be required to consider?
Concurrent bench. Judgment also.
What concurrent bench judgment? Which concurrent bench judgment? Regarding compensation.
Of this book.
And this one, what other judgment you are?
Other than I was Kerala. We are also doing.
Kindly give us a citation, madam.
Okay,
Mm.
Actually, but since he was being elected, and it's a part of the political him and he was for years almost, he was deprived for the being principal. Why not?
What is the other judgment, madam? The Supreme Court judgment, what part do you want us to read?
Chairman of the persons who are illegally terminated, then when that's being their application. Paragraph 13. And what paragraph 13 is 13. Yeah. There are no justification to take with the period during the explanation of the paragraph 54 also, page 13 and 43.
Okay.
Public service affects Article 14.
This is which one? This is which one?
Not that, but madam.
You can give us the citation. What is it? A note?
Salient point.
Of?
And my lord, like. Whether my lord, on significant appointment can be required by the officer. So this one significant appointment because appointed in the official guidelines. They're bound to follow the official guidelines. They have not said that 6 months or any years. They have done it, the minimum 1 year has, the 1 year has was not given. And secondly, my lord, the person affected, how he could be compensated. My client is satisfied, he has been, my lord, appointed, because I school, my lord, I serve for down to the following our higher secondary school. So whatever remaining services there, it's transferred to also. I cannot that some other financial benefit like extra other protocol because that from the different increment. That is limited priority because that is still my nothing can be already been selected again appointed. But he is having an because he was illegally deprived. Otherwise, he could but he's been illegally deprived, the illegality should go, that is finally take care. And if possible, so all for area started start in the school. I'm sorry for the this year.
No difficulty, no difficulty.
Deeply observed.
Hearing computer judgment. Attendance. Yes, sir.
My friend was here. We have verified that one record of the initial.
Yes, sir.
No, no,
Are
my
they
rule is,
using
my
it?
rule is only limited to whether the UDIS is fake or genuine.
That is the
That's all.
entire question.
It is all the respondent. So if you will give me some time to get it, Mal, because the entire offices and between financial matter whether that online meeting is going on with Delhi, my lord. My annual meeting is going on, nobody is in office, my lord. So that's the difficulty I'm getting the lots of picture of Wednesday, my lord.
Wednesday?
Monday is also closed, some vacation holiday is there.
Something outside the school.
Yours is an elementary school.
And my lord,
You send them, you ask them to go and attend the Anganwadi.
no, no, not.
The Anganwadi center. Let them go and attend the Anganwadi center. They'll have some playtime. We'll adjust the attendance in your school. We'll say they were attending your school. We'll make an of them. Huh?
No, no,
They have to be somewhere. We understand.
because, thereby also, my lord, as per the equal order, there is no any class that they.
This is where this is Nagaon.
No,
No, some park. Picnic for Monday and Tuesday. Wednesday we'll have the kids. A picnic on Monday and Tuesday.
Fine.
Wednesday we'll have the.
Wednesday and get it.
He will have to have his information,
that's why
what their record says. If they say it is a genuine,
their record, we have made a part of our petition in the additional affidavit also.
Mm.
Website.
Hmm.
That specifically discloses that this transport belongs to the petitioner. Specifically, prima facie, we have made out that the allegation at the ground which they have taken is not in tune to the record.
who appears for the deputy commissioner? District commissioner, you appear. And elementary education, inspector of schools, secondary.
By the education secondary.
Mr. Sharma. We are taking up this matter on Wednesday. Huh? Where is that FIR?
Not FIR copy, that we when not heard also.
Where is the FIR? Do you have the FIR copy?
Yes, we can make it a part of the.
Mr. Sharma? Yes. One of your inspector of schools of Nagaon has lodged an FIR against the Universal School or what?
United.
United School. United English School. Huh? Have your instructions on what basis he got that? He lost the FIR. He has lost an FIR saying that the UDIS is false. So either he comes before the court to say that those documents did not go through the CRCC. They are all fake documents. We don't know what is the report is fake, this and that. Or he says that yes, it went through my office, but the signature is not mine. Something he will have to say. Are they party in this?
Yes, sir.
Then give him a PDF copy of the
Yes, sir.
repetition so that he can forward it to the IS. District Commissioner, you have conducted an inquiry. Yes? You have issued the order dated 28 April 2026. You have done it as per the allegation without hearing the petitioner. There are students studying. Who was heard? Someone must have been heard. You are closing down a school, sealing it. Tell us, who was they heard or not? Were they heard or not? And Mr. Bora, kindly have your instructions regarding the correctness of the data available in the website and also whether there is any other data in the name of Popoha Adoho Jatiya Vidyalaya. And Mr. Sharma, you will have to tell us how did the file name change? If you see the order at page 49, file was processed in some name and some other school gets the DIAS code. Ah, tell us. Tell us.
It is a gender issue by the inspector of school. will be, head of the all private schools, think it is right. Think some schools do not meet the requirement. Unless both from paragraph one. It has been observed that in many private schools in Gauhati district have been operating without possessing necessary documents for appeal reports, etc. Many schools which have received the permission for new tires specifically before 2024 have not been applied for the provisioning of the finance registration. Higher going for the prior condition stands invalid. Such type of activity is not as per law and creates many management problems with regard to education entities. Therefore, you are hereby directed to update all necessary documents if not updated immediately via so for an intimation to the undersigned. Moreover, no new private school is hereby allowed to open without the permission of the competition as per norm and as per the requirement of their financial. Now, my complaint will not there bring this better before my lawsuit is that only this school has been targeted that you have even Miller, if you assume Miller that we do not have the highest data, correct? Then these other schools are being allowed to operate.
That is another chapter, sir. The allegation against the other school is that you are operating on false DIAS data. DIAS data, no one knows the importance of a U DIAS data than other than Mr. ARVM. DIAS data certificate is something, it is the Aadhaar card, it is the passport, it is the PAN card, it is all in one for the school. It's very important. But here they are saying that you are not having the documents, kindly give us the documents.
Even does now have thank you online, it is in my name.
No, they are saying that the file was processed in someone else's name, somehow it got uploaded. Let us see who did it. And Wednesday, list again on Wednesday. They have another DIAS data. They have another DIAS data. List again on Wednesday. 3rd of June. List of Mr. S. Bora, Learned Counsel, appearing for the SSA, comma, Mr. appearing for the, you are appearing for, madam?
4 and 5.
4 and 5, who is 4 and 5? For the district authorities. And Mr. Sharma, you are appearing for the rest of them? 1, 2, and 6. Who appears for elementary? Who appears for elementary? So and so for elementary. Shall have their instructions as required by this code. Full stop. The prayer for interim relief shall be considered on the next step on the basis of the instructions to be presented by the respondents. Full stop. Absence of instructions may lead to adverse orders from the school. Have you instructed all of Bhushan. Yes, ma'am. Yes, madam. Yes, sir. What do you say, Mr. Dax?
First of all, our name is not showing in the post list,
Done.
Second is, the notification which has been challenged by the petitioner is of 7/12/2024, and that too transfer, now.
Where were you for the last 2 years?
It was not acted upon by the respondent themselves.
Okay,
And the
another
petition is
submission,
still working. No release order is also issued.
Okay, then.
And another submission, that it is a settled provision of law that that if the transfer is challenged, that person has to first join that service, then can only.
Yes, in 2024, you issue a transfer order. Then what happened?
Here, the petitioner.
Then what happened? Thereafter, what happened? Can you tell us when did you issue it? When did you issue this transfer order? 2024.
2024,
Then he made an application on 10 December 2024. Yes? You did not issue any release order. Yes? No release orders. 23/12/2024, another order is passed regarding some other persons. Then 17 June. The VC constitutes something, and where is your release? They have not released it till now.
No, my lord.
Yes.
And extra J paid for.
When will you have your instructions?
Give me some time, my lord.
Don't release it. Don't release it.
First of all, I haven't gone through this matter properly because our name was not shown, my lord. Just got to know a few minutes back. Or fix it on
When-
Monday,
when
my
will
lord.
you have
Monday or
Monday?
Tuesday, I'll do it. Monday or Tuesday.
The heard Ms. Swanson and counsel paying for the petitioner, also heard Mr. Aircraft and counsel paying for the respondent number.
I'll be paying for, my lord,
Respondent number 1, 2,
1,
3, 4.
no,
Good
1,
stuff.
3, 4, 1, 3, 4, my lord.
Why not 2?
2, my lord, Assam Science and Technology University.
Who have you?
I think they have pending also.
Who? They don't have a selling counsel.
Sir, copy.
You are paying for
Lordship, I am appealing for respondent number 5. Lordship, I am-
respondent number 5, madam. Yes, Ms. Das,
Yes, sir.
are you appearing in the matter?
No, I don't want to fight.
The repetition has been filed, praying for interference with the 2024, whereby amongst other incumbents, the petitioner had been transferred to the Bineshwar Brahma Engineering College on promotion as a promotion to the post of professor. Full stop. The petitioner had made a representation on 10th of December 2024. Full stop. By later orders, other professors and associate professors were also transferred. Full stop. On 17th of June 2025, the VC of the Assam Science and Technology University constituted the Board of Studies for Instrumentation Engineering, with the petitioner as the chairman. Full stop. Such order has not yet been recorded in date. Full stop. It is the case of the petitioner that the transfer order being issued in the year 2024, the same was not given effect to, and the petitioner has not yet been released from his place of posting at the Assam Engineering College, Guwahati. Full stop. The petitioner still continues to be the chairman of the Board of Studies as appointed by the order dated 17th of June 2025. Full stop. The counsel for the petitioner has submitted that the petitioner is due to retire in June 2027. In June 2027. Stop. The counsel for the petitioner had submitted that when the transfer order had not been given effective for more than 2 years now, for nearly 2 years now, the sudden effort on the part of the respondents to release the petitioner now would be to his detriment. Full stop. It is the specific submission of the counsel for the petitioner, on instructions received from the petitioner that the petitioner has not been served with any release order till date, and he is continuing to discharge his duties in the Assam Engineering College. Mr. Das, the counsel appearing for the, sorry? The counsel for the petitioner has submitted that at the back end of the service, the transfer may not be given effective. Mr. Das, the counsel appearing for the engineering college and the authorities in the engineering college has paid for an accommodation of till Monday next. When do you want?
Tuesday, my lord. Tuesday.
Tuesday next. Tuesday ki date ho? 2nd of June to have his instructions in the matter. Full stop. Since it has been submitted that the petitioner has not been released from his place of posting at AC, status quo as on today to be maintained on till Tuesday. Till Tuesday. further continuance would be considered upon the counsel for the respondent submitting his making his submissions on the basis of instructions. Pension, yes. Yes, let us know what is the
Instruction is that record has been called for from the DEO lot for due process. And the record has been received on 26th of May. So lordship will fix after 3 weeks. Something.
when did you retire? Yes, by Tuesday will you process it?
Lordship.
By Tuesday.
We will not do-
2019, she is not getting pension. Provisional? Provisional?
Otherwise, This is a, the petitioner was on ad hoc basis, lordship. So. In fact, already we have filed our affidavit and we have cleared our stand earlier. But pursuant to the order of this honorable court, this
2 weeks. No way out.
3 weeks. 3 weeks.
Huh?
3 weeks. It will take some time, lordship, because that period has to be regularized.
We agreed to 2 from 0, you are now going to 3. Huh? This matter again on the 24th of June, 2026. Mr. P.N. Sharma to place his updated instructions before the court. Instruct the council preparing for the department that submitted to the affidavit has already been filed.
In fact, already filed.
Has it been filed yet?
Clearing our stand that the petitioner was on ad hoc basis.
Stating that the petitioner was serving in ad hoc basis, although her services for the last 28 years has not been denied. Have you denied that she was serving you for 28 years? No.
That service
She was in government serving for at least 10 years.
subsequently
Process the pension. What does it say? If they have served you for 10 years, entitled to pension. Fourth of June, no? 24th of June. Yeah, it has been submitted there. The relevant records have been called for from the district officers by the joint director and the same is under process now.
Here, awaiting instruction of the director is written to the government, but they are awaiting instruction from the government.
Regarding what, you were under suspension? Then you were reinstated. For that period, you have not got any arrear salary. And the period of suspension was regularized.
Yes.
By the order at page 25, yes.
Yes,
It's positive.
Yes.
the director has written to the government for approval, my lord, and we are awaiting that instruction.
But otherwise, you're not denying the claim.
At this stage, I will not say.
Because you have regularized it.
Yes, regularized it. There is an order.
At least 38 minutes.
Huh?
Yes, 38 minutes.
Mr. P. Kaushik, Planning Council, Elementary Education Department has paid for an accommodation to have updated instructions in the matter of stuff. The council for the petitioner has submitted that the period of suspension of the petitioner have been regularized by an order dated 28th January 2020. 24 January 2022.
24.
17 October
24 January 2020. That is
24th of January 2020. Full stop. The Learner Council has submitted that the proposal had also been submitted. However, the further process is not known. Full stop. The non-royal certificate was also issued by the concerned treasury officer. By the concerned deputy inspector of schools. Full stop. Place the matter again on the 10th of June. 10th of June?
Yes.
Allowing Mr. Kaushik to have his instruction. It has already been observed that the tendency of this applicant shall not be a bar for the respondents to release the arrear salary, if he is entitled to the same. The respondents should also be at liberty to file their affidavit in opposition, disputing the entitlement, if any.
Get to.
Yes.
Here I am impleted later on, my lord, newly impleted now for SCRT, my lord. Need some more time to get the instruction. My lord.
He got a certificate.
No, no,
He got a certificate.
he got certificate.
And you are saying no record.
No, no, well, I will have to get the instruction. It's coming for Hailakandi.
I can understand it exactly. So that, what has happened, last, there is a second round of litigation. Previously also the petitioner has that. There is a specific direction of the honorable to court to consider the case of the petitioner regarding under the old pension scheme. But what has happened now, they are disputing the fact that the certificate and all these things, this will not be taken into consideration at the litigation. I'm having the judgment here, when I have mentioned in my pleading also, there's a judgment of the common court. In that particular judgment, the common court has categorically mentioned, these are all stipendary teacher. And irrespective of the fact whether they are, this participated in the selection process with regard to the basic training, they should be considered under the old pension scheme. Worship, kindly see this particular judgment, I am putting the judgment. I've given check mark with regard to certain relevant portion. The case of the petitioner is.
But unless we give,
5037 of 2000.
unless we give them an opportunity of their affidavit being on record, will that not be the sole ground
It's the judgment.
to
passed.
delay your relief?
My learned friend is very much aware about this particular judgment. When the restriction also I made a mention with regard to.
But you have been kind enough not to give us the first name.
This is a voluminous.
No, the first name, the first page.
This is a
Which is his judgment? Punima Hore,
Yes, Lord. I feel.
stipendary.
Yes.
Then
My name is then the first flag.
you have destroyed the entire certified copy.
Worship knows about the judgment.
Now, Purnima Hole says, if a person is going to be a stipendary teacher, he will come under the ambit of full pension. No denial, no dispute, no quarrel. And here is the case where he is being released in terms of Purnima Hole. He claims himself to be a stipendary teacher. Whether he is a stipendary teacher or not, that is to be.
It is not a dispute at all in this case. It is an admitted position. He is a stipendary teacher.
Oh, stipendary.
The dispute is the SCRT which trained him, that certificate. Sir, we don't have a record of the certificate, everything taken away by the CID or someone, and now we don't have access to it, we don't know.
So therefore, the employer will have to confirm.
Employer, who is the employer?
Will have to confirm.
You are the employer.
Yes, SCRT, I'm for the SCRT. That's why, my lord.
You are only the certificate issuing authority.
Yes,
Yes,
He is a teacher of the elementary education officer of the elementary education department.
Let me get the instruction, my lord.
Are you disputing that he is a stipendary teacher? Huh? And what is the ground for rejection?
Nothing lost. For last so many years, the petitioner is submitted the representation of.
What do you have at page 38? What is this page 38?
Page
Page 38?
Page 30.
Where?
30.
You are asking for time scale of pay. You are talking of old pension scheme. Time scale of pay you will get if you have got the training.
Yeah.
If you give up that time scale of pay on the basis of the absence of the verification of the training, I can allow you to be under the old pension scheme today itself. Scale of pay should be there. Then that verification part has to be carried out whether you are entitled to a time scale of pay.
Yes.
Time scale of pay would only come if you have qualified the training, is it not?
Yes, but
So therefore, they are raising that grievance. Old pension scheme, no one, they can pass on order tomorrow that you'll be under the old pension scheme. The moment you retire, whether it is on a fixed pay or on a time scale. If you were if you didn't complete the training, you would not get the time scale, perhaps. Then whatever was your fixed pay, your pension will depend on that. Under the OPS also. On a fixed pay, you will get your pension.
here in this case, the difficulty is that the petitioner has cleared the exam, they have for the full one.
That is the whole issue. He wants some time to clarify because when the records are not there, the police have taken it. There were some other sources from where they have to verify it.
And this particular
apart from the certificate loss, you kindly see the RTI reply, the connection to page number 27,
27 years.
page number 27. In this particular reply, they have mentioned about the error with the increase dated 20 May 2004, data, but got it, column number 2, page number 27. In this particular,
You are roll number 60, done.
60.
Ah.
So I cleared the exam in the year 2004 only.
That is on the basis of a photocopy. The entire problem is the office has photocopies.
The letter that
It is a photocopy of that letter.
has been issued by the HCRT, RTI reply, that is.
They have given you a RTI reply, sir, whatever is there available in the file, I'll give it to you. Neither is it my opinion, neither is it my investigation inquiry report, it's nothing. If this is in the file, please take it. This is the information. That's it. That will not take you anywhere. How do you dispute his training part? 22nd of June, final opportunity. Mr. S. Bora had already taken opportunity on 18/5. Yes. On 18/5, you had taken the time. Now we fix it on 22nd. I will get it. Either file your affidavit or Mr. S.P. Chaudhary, learned counsel appearing for the petitioner. 22nd of June. Also heard Mr. S. Bora, learned counsel, standing counsel for the SCRT, who seeks an accommodation to have his instructions on the certificate issued to the petitioner in the year 2024, full stop. The prayer of the petitioner is for grant of a regular time scale of pay on his qualifying the relevant training under the SCRT and also for inclusion of his name under the old pension rules, no, and inclusion of his services rendered under the old pension scheme of 1969. Full stop. The learned counsel for the petitioner submitted that the issue as to whether stipendiary teachers like the petitioner would be entitled to the benefits of the old pension scheme has already been settled by this court.
Yeah.
And therefore, full stop. However, it is because of the delay in verifying the qualification of training of the petitioner that the matter has been delayed till date. Full stop. The respondents shall file their affidavit in opposition on or before the 19th of June 2026, clarifying their stance in the matter. Full stop. Let the matter be listed again on the 22nd of June 2026. It is made clear that in the absence of affidavits or response by the respondents on 22nd of June 2026, which court will be constrained to call for the concerned officers to explain the delay in filing responses to the petitions. So, 19. You file it by 19th, we are having it listed on the 22nd. Now, if we find that he has an entitlement, if we part. The Mr. Gauhati, the learned counsel is being from the finance department of submitted that the list which has already been submitted by the promotion department to the finance department containing the names of which back and day prepared as then available between department did not contain the name of the petition. However, the cases of all the other secondary prepared which is provided by the department has already been considered by the finance department and appropriate approval comma where emphatic comma has already been granted. He has referred to the instruction dated 19th of March 2026 issued by Telangana also. Yes, issued by the Deputy Secretary of the Finance Department.
Okay, this matter can be taken after some time when Mr. Gogoi is appearing on next input 6. After some time.
They have filed their affidavit, I predict the vote of the. I submitted and kept the because of next of kin. If there not a speech was taken, if the two guys were asking other activities, I feel what if there is one person, either to consider by profession of self-defense. Simply file or.
Your name is there in the service report? Is your name available in the service report and all? We'll calculate after some time in the presence of Mr.
Front of the health record, that same line.
We'll have to travel around 2,600 kilometers for that. We don't want to do it now. We will take it up after some time in the presence of Mr. Gogoi. Okay, at 2. At 2.
Petition of the authority, they are not taking in for that. It was of with that.
We were proposing prior to 2 if Mr. Gogoi was.
Lordship.
If you want it at 2, we can have it at 2.
Priority to go.
Actually, today, Friday, they are lordship. Before. At 1, before 2, lordship, you are lordship.
We'll have it at 2, sir. We will have it at 2. Tell us. Huh.
May I please your lordship? In this case, we have not received any instruction. And another thing is that now, there is another recruitment commission for the apartmental gate 4.
Recruitment commission, he is asking for provincialization, is it?
Yeah. For the gate 4 employee.
Provincialization. He was already working there. He provincialized so many persons. Why not him? Grade 4 appointment will come as and when it comes. Have you seen that order dated, order on page 27?
Yes, ma'am.
That will not suffice. It suffices for him.
Yes.
Will it trouble you? Tell us that. You completely dispose of their representations.
My lord. As for the 10. It can.
But Mr. A.M. Council. A.M. Bovialan Council is paying for the petitioners. Huh? The petitioner. Also heard. We spoke on Learned Council is paying for the Department of Elementary Education. That is a respondent number 1, 2, 3, and 4. Each of the respondent number
1, 3, and 4, my lord.
1, 3, and 4. The finance department, who appears for the finance department, Mr.
1, 3, 4, and 6, my lord.
Panchaliya and considering for the respondent number 2. You are paying for 1, 3, and
6, my lord.
1, 3,
1, 3, 4, and 6.
1, 3, 4, and 6. News to come and it's empty. You are paying for Miss Respondent number 5. So all represented? Neat. The learned counsel for the petitioner has submitted that although the claim of the petitioner has been forwarded twice for provincialization by the DLC to the SLC as a grade 4 employee in Singarbon ME Madrasa, Kachar. You'll find it page 8 on online book. There has been no finalization to the aforesaid proposals. The learned counsel for the petitioner has submitted that under similar circumstances, the spot by the order dated 16/7/2025, passed in WPC 2631 of 2025, had directed as under. Para 8, page 29, para 8, para 9, para 10, para 11, para 12, no, para 8 particular. The learned counsel for the petitioner has submitted that the grievance of the petitioner would be redressed at this stage in the event similar directions are passed. Full stop. The learned counsel appearing for the Department of Education does not object to the prayer of the petitioner for filing of a representation and having the same disposed of in accordance with law and in terms of the orders passed under similar circumstances by this court. Full stop. Accordingly, this petition is disposed of, requiring the petitioner to file an application of the representation before the Secretary of the Government of Assam, BAC, along with certified copy of this order, stating his claim for provincialization of services by highlighting the steps that has already been taken in this connection by the respondent party. Full stop. On receipt of such representation, the Secretary to the Government of Assam, the SC, Department of Revenue, shall consider the same along with contemporaneous reports, and in the event it is found that the petitioners were not properly considered by the SLC, required the placing of the case of the petitioners before the SLC for scrutiny. Full stop. In the event the SLC proceeds to favorably recommend the cases of the petitioner, the Secretary of the Government of Assam, DSC, shall take further steps for provincialization of the study. Full stop. In the event the findings of the SLC are not favorable to the petitioner, the same shall be communicated to the petitioner within a period of 15 days of such decision. The above exercise in all aspects shall be completed by the respondent authorities within an outer limit of 3 months from the date of receipt of a certified copy of the order. Date petition disposed of. Pay protection. Why were you freshly appointed? When is your first appointment? 2013. Okay, and when is your second appointment? You applied under a new advertisement through the department and everything. Yes, why are you not giving him pay protection, sir? How can you not give him? You have filed your representation. You wanted disposal of the representation, or you wanted disposal by this court? Heard Mr. We are disposing it of then. Heard Mr. S.B. Laskar, Learned Counsel, appearing for the petitioner. Also heard Mr. U. Sharma, Learned Standing Counsel, Secondary Reviewing Department. The petitioner in this petition was initially appointed as an assistant teacher at where? Where is your name, sir? At the Pohumora LPS by the order dated 28th of June 2013 issued by the Director of Elementary Education, Assam. Full stop. The petitioner had joined her services and was continuing in the same in the pay scale of rupees 5,200 20,200 plus grade pay of rupees 2,500 per month with other allowances at admissible under the rules. Full stop. The petitioner had thereafter participated in another selection process, applying to the proper channel and with proper NOC, and having found to be fit for selection and appointment, by the order dated 19th of April 2017, the petitioner had been appointed in the Kotoha Tribal ME School. Full stop. By the order dated 1st of November 2017, the Kotaha ME Kotoha Tribal ME School, the Kotoha Government Senior Basic School, and the Kotoha High School were amalgamated and were further now known as the Kotoha High School. Full stop. It is the case of the petitioner that she had not been afforded a pre-protection when she had been appointed in the year 2017, and her past service as a teacher under the same state government, which was given effect to by the order dated 28th of June 2013, has been ignored by the respondents, causing her financial loss. Full stop. To this end, the petitioner had filed a representation on 28/5/2018. Oh no. 25/8/2018, which was forwarded by the Inspector of Schools to the Director of Secondary Education by the communication dated 6/9/2018. Full stop. The petition, it is the grievance of the petitioner that the petitioner has not been afforded her pre-protection thereafter. Yes. Is that necessary? The petition, it is stated on behalf of the petitioner that the petitioner has also, the petitioner has been afforded the benefit of a mutual transfer from the Kotoha High School to the Sri Bangur High School, located at Dibrugarh. The learned counsel for the petitioner submits that since the representation of the petitioner has not been disposed of, appropriate directions may be given to the respondent authorities to consider her case and pass appropriate orders, since at this stage, the stand of the respondents for denying the petitioner her pre-protection is not clear, and the respondents have not filed an affidavit in opposition, although notices were issued way back on 1st of September 2025. Full stop. Mr. U. Sharma, learned counsel appearing for the Secondary Education Department, has submitted that he is awaiting instructions in the matter. Full stop. In view of the submissions made by the learned counsel for the petitioner, this court, I am of the view that the petitioner that petitioner, and since the petition, a prayer has been made on behalf of the petitioner that the matter may be remanded to the respondent authorities to take a decision within a specified period of time, to which prayer the learned counsel appearing for the state respondents does not object to, this petition is disposed of, directing the Director of Secondary Education to take on record the representation dated We'll do that. We'll come to that. The representation dated 28/5/2018, which was forwarded by the inspector of schools by his communication dated 6/9/2018, and thereafter and pass necessary orders, comma, either accepting or rejecting the claim of the petitioner for his pre-protection, full stop. The learned counsel for the respondent has submitted that the application dated the application filed in the year 2018 may not be would require some further support in the form of documents from the end of the petitioner, and therefore, and a full stop. Therefore, this court also grants liberty to the petitioner to file a detailed application along with all relevant documents before the Inspector of Schools Dibrugarh within a period of 15 days from today, along with a certified copy of this order, including copies of the earlier representation, comma, which documents shall be forwarded by the Inspector of Schools after proper examination to the Director of Secondary Education, full stop. The Director of Secondary Education shall thereafter pass necessary orders as already directed herein before, full stop. The entire exercise of consideration of the case of the petitioner should be completed within a period of 2 months from the date of receipt of a certified copy of the order by the Inspector of in the Office of the Inspector of Schools, comma, Dibrugarh. Read petition disposed of. No order as to costs. Yes, next. That will be school corner, but otherwise the transfer and what part is different? ইয়াতে খালি হেতু নিদিবে এই স্কুলৰ নামটো কি কৈছে when were you first appointed? You find that page 10, huh? Page 10, footnote 9. ডাঙৰকে serial number 3. That was প্ৰথম speaker, প্ৰথম appointment পাতিল 17 of 17 of appointment হ'ল Isam কিনাৰে নিয়ে সেটো আপুনি কত পেজ 14 মই ঠিক নাই কিছু না নামটো পাতি যাব স্কুল তার পিছত আপনি দিব কাউন্সিল সিগনেট করতে হবে প্রোটেকশন পিকআপ করতে তারপর সেটা প্রোটেকশন করতে মিডিলে মিউচুয়াল ট্রান্সফার পার্টি দিব না হবো তার দিকে ডিসক্লোজ অফ নো কস্ট will allow them to file the affidavit. Miss Pepper Secretary and Council, learned additional senior government advocate has submitted that they have that she has received the appropriate instructions and the affidavit has also been prepared. Mr. BP Boral and Council appearing for the petition and has submitted. What is the subject matter? That the subject matter of the petition revolves around the dismissal of the petitioner from his service and also as also the dismissal of the statutory appeal, and that the matter may be taken up at an early date since the petitioner is suffering from non-employment. Accordingly, list this matter again on the 25th of June 2026, by which time the learned council, the learned additional senior government advocate has assured that the affidavit response would be filed. The petitioner would be at liberty to file their response to the affidavit of permission before the next date of listing. Mr. A. Chalihan and Standing Council Health submits that although efforts were made to file the affidavit in opposition on or before 19/5/2026, due to the affidavit would be filed today itself. Instead of the council to the petitioner will be at liberty to file the response to the affidavit in opposition, which is proposed to be filed today before the next date fixed. list this matter again on any urgency in the matter. 20th of July 2026. Yes. Ah. Hmm. 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 Ah. Ah. Yes. Yes, sir. Why are you not proceeding with the matter? 6th of June. Hmm. 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 We'll have it sometime after the June. If the finance department agrees to the provincialization of teachers, good enough. Or they may even suggest the fresh appointment or recruitment, we do not know. In that case, we will adjudicate. But if they agree that yes, you can be accommodated, what means, okay, what means, what means, people work and council of paying for the people. It's what also what means by use Sharma, the next pending council, paying for the secondary education department. It's what means by Sharma, but then council has submitted that a joint section, a joint sitting between the Department of School Education and the Finance Department it is scheduled to be held when is proposed to be held to consider the case of the petitioner, which the instruction provided to this court specifically mentions the WPC number, the present WPC. As such, this is matter again on 24th of June 2026, allowing Mr. Sharma to apprise this court the outcome of the proposed joint sitting. Hmm. Hmm. Where are you going to file the affidavit? Question is one of regularization. When will you file the affidavit? We'll have it on the 26th of June, allowing her the time to file affidavit. Because you don't have an intent where there is nothing to be considered in the intent. Let the affidavit come. Miss H. Therampi, Planning Council, Secondary Education Department has paid for an accommodation to file the affidavit in opposition in the matter, submitting that since it relates to a grievance, since it relates to the regularization of the petitioner, full stop. The counsel for the petitioner has paid for accordingly list the matter again on the 26th of June, according the according time to the respondent authorities to file their affidavit. Yes, sir. Ah, why should it be three? Why should it be three? Huh? Hmm. Hmm. No, three were provincialized, but one expired. Therefore, you want your consideration to that post. The act says that if someone is offered the provincialization, the post has to be filled up by way of regular selection. Hmm. Oh. You are provincializing a dead man. Huh? The man died, and yet they don't have to provincialize him. So with the condition that he will not be entitled to anything before his provincialization. Yes, affidavit when? Right? You approach in 2025. For 4 years, we can give him 4 weeks. Not under litigation. We'll have it on the 24th of June, 2026 for your affidavit opposition. Huh? Mr. A. Pupon, the counsel appearing for the Elementary Education Department has submitted that he would that the affidavit opposition would be filed on or before the 24th of June 2026. Full stop. On such assurance, this court direct the matter to be listed again on the 26th of June, along with the affidavit supposed to be filed by the respondent. The matter relates to the prayer for provincialization of the services of the teacher, and there have already been 2 rounds of litigation prior to this. This is the third one. Yes, sir. Hmm. 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 This penalty, this preliminary inquiry report was not submitted, was not given to you at any prior point of time. He holds the preliminary inquiry, he holds the final inquiry. Hmm. 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 Or the person who conducted the preliminary inquiry is also the person who is the inquiry officer. Yes. Huh. Done 70. Hmm. Huh. Hmm. Oh. Just a minute. Thirty, seven. Hmm. Hmm. But does it bar the, PTN bars the discipline authority to the inquiry? But our reach do not, it allows where it is not. Ah, hmm. Yes, sir, rule 92. Hmm. 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 Yeah.
71, that is 25th of November 2024.
Ah.
If your lordship looks into it, from Anushwa Datta, that is my DA, under 9.2 in exercise on the first sentence of page 7, in excess of
9.2,
power conferred under 9.2. Rightly, 9.2. And my lord, at page 72, C is my DA. Right. Now, the enquiry officer appointed. Now, please see the additional affidavit for time being. Affidavit in opposition filed by the government. At page 160. 160. Now, please see at 160. Now, this is of January 2025, where an enquiry under Rule 9 of so and so held in charges to him so and so. Now, therefore, third paragraph, in excess of power conferred by so and so is pleased to appoint Srimati Anushwa Datta Barua, Secretary Government of Assam so and so, as an enquiry officer to inquire into the charge same against so and so against so and so. So she is a DA. Now she has been appointed as an enquiry officer. And now normally, my lord, once the enquiry officer appointed, the inquiry report has to be forwarded to DA. Now, according DA will give a reason, give a so cause to me, why this inquiry, then what action has to be taken, what reply you have to pass, what reply you have to submit. Now, please see, there's stand at page 151.
Huh?
Stand of the document. At page 151. Paragraph 4. That with regard to the statement made in para 3 of the writ petition, deponent begs to state, averment made therein is not factually true. Disciplinary authority is well defined in Rule 8 of so and so. Respondent number 5 was appointed as an inquiry officer to inquire into charges drawn against the petitioner in the departmental proceeding by the DA by order dated 24/1/2025. The order dated 4/8/2025 was signed and issued by respondent number 5 only after the approval of the DA. As such, in the DP case of the petitioner, it is crystal clear that a DA inquiry officer was not the same person. Now, what they stand, the deponent begs to say order dated 4/8/2025 was signed and issued by R5 following due procedure and with the approval of the competent disciplinary authority. Their statement, what they are saying now, DA inquiry officer was not the same person, was a different person. Now they have to show, my lord, that whether it is the same person or not. I have shown it is the same person. Now
The same person holding the post here issues the so cause.
Yes,
Coming to this post, now he starts as the inquiry officer. That
that's
is
right.
your-
That's our case. Now second point is about the, my lord will please see 102, my lord, of the inquiry, the report. At 102, that's the second point. Second point of determination. See, my lord, 5. The finding of the inquiry report conducted by the Commissioner, Food, FDCA and LM, Food and Civil Supply Department, Assam, produced by the PO. So now, if your lordship kindly see inquiry report, your lordship will find at page 83.
So there is a small problem. And we have to rise it quickly. Oh, our bench is a bit long. There is a reference.
No problem, my lord. Only difficulty, if not today, the lordship can fix a date, so that this man is retiring. Otherwise, I would not have troubled this court, my lord.
At the age of superannuation, he's already compulsorily retired. The penalty is compulsory retirement.
Yes,
if
yes,
I'm not-
compulsory.
So he's already retired.
No, if it is now, I don't know what will be the outcome of the
And
case.
if it is in the positive within the month of June, perhaps a reinstatement for 1 or 2 days.
Yes, that's
And
the,
otherwise,
that's the only,
the period of illegal termination,
uh,
that will be counted for notional benefits
yes.
and everything.
He'll get the benefits.
We'll try it on the 16th of June.
Thereafter, any date which is
18th of June. 18th is possible.
18.
Okay, list again on the 18th of June. And 26. Your pleadings are complete, sir?
Yes, the pleading complete
Pleadings are
reply.
complete. We take it
Yes,
up for disposal.
A pleading is complete. I have
So we'll
filed
take it up for disposal. You would have the records with you on that day?
record part of the, I did not complete the record.
I have it completed on the 18th of June.
Yes.
On the next day, kindly have the record. Because,
This record.
Mr. P.C. Sutia, when it comes to, Mr. Vidas Connect Senior Advocate assisted by for the petitioner first. Mr. P.C. Sutia, Senior Counsel, additional senior government advocate appears for the respondents with the assistance of This is matter again on the 18th of June 2026. on which date the additional senior government advocate shall have the records of the discipline proceeding in issue available for perusal of the perusal by the court.
16 June.
18.
My learned friend will try to find out whether DA and the inquiry officer are the same person or not, because they say, name is
Since-
only they are saying that they are
Since,
taking approval.
since it has been observed that the matter will be taken up for disposal, the Gauhati council is paying for the respondent shall also have his instruction on the points argued regarding the DA and the inquiry officer and the same person.
I am deeply aware.
Yes,
This matter relating to non-releasing pension and retirement benefits. On the ground that my initial entry was on temporary inadequacies. And in fact, Lordship, my service has been regularized with effect from 12/12/2005. And I have left the service from 31/12/2010. Because I was subsequently, Lordship, not allowed to join. So Lordship, I am not going to latter part, and in the meantime, the petitioner has retired. The pleading has already completed as the matter is relating to pension. May I pray, Lordship, can it be taken up on 9th of June, Lordship? If possible, Lordship.
subject to 9th of June, it can be subject to availability of space. Asa 9th of June antara, huh? 9th, 11th is full.
And then,
16,
Lordship, 16, Lordship, I have some,
18,
Lordship,
18th of June. Hearings are complete, list for hearing on the 18th of June.
money.
Oh, kita loh. Yes, sir.
That's an item number 62 and 76. In fact, I myself fix this matters for today. But Lordship, in the second half, I have some difficulty.
Anyway, after 3:15, the court has to rise because of the preference. So when would you like to have it?
Anyway,
Lordship,
Tuesday?
can it be, this item number 76, can it be kept as a part heard, your Lordship, so that
Item 76 to list again on 2nd of June.
first or third?
3rd of June as a part of the
third letter of the Lordship, on that's makes quick. I mean,
8 of June. That's a part of matter. That is item 72.
76.
Item 76. And what is the other item you had said?
Other one is 62.
62.
Yeah.
62. Item 62 is academic review list of people to.
A lot. I have informed them that it's a biggest way.
Next.
Yes, Mr. Sonu.
Time there, pension matter, that may be fixed.
You are ready to give them time.
Short date matter.
Mr. Yusham and consulting for the state respondents. He has paid for an accommodation for 2 weeks to file their affidavit, 3 weeks to file their affidavit in opposition from a full stop. Since the prayer is not objected to by Mr. Sharma, who submits that the filing of the affidavit is for adjudication of the matter, place this matter again on 19th of June, on which day the respondents shall ensure that the affidavit is on record. Yes, Mr. V.
My senior friend has a matter, I am for the respondent, 55 minutes pension matter, an affidavit from the Panchayat and Rural Development.
That will be right.
Person is required to be filed. That is not yet filed.
We'll have to take it up at 2 because they would not be expecting us to pass an order in their absence.
Mine. Or my lord, can you?
They might have it ready, they might be filing it today, we do not know.
Mine.
Let it be, let your assistant counsels be here.
No, my lord, I will be.
If none is there, we'll. At 2.
Kaushik, here in this case, today I have filed, on the last occasion, I filed an application for amendment of the writ petition to incorporate the name of the person who has been transferred in my place with certain specific amendment with regard to that. That has been allowed. And today I filed the amended petition, Lordship. I was supposed to call for, but it has not been called. Can it be taken up on Monday, Lordship, along with this amended petition, Lordship?
Mr. S.P. Chaudhary, Learned Counsel, appearing for the petitioner, has submitted that the amended court settlement
Yes.
is filed.
Yes, amended petition, Lordship.
Amended petition has been filed, list again on
Monday, Lordship.
1st of June, 2026, along with the amended petition.
God bless.
I don't think the service book, Lordship, no legal heirs name is there. But PAN card and Aadhaar card, everything is there, Lordship. And that apart, Lordship. Just, I am submitting, Lordship. Since they are,
With the time that we have today. Yes. If it is short, we can,
Lordship, one thing is that, Lordship, since both the wife as well as children
they agree.
agree, Lordship. I have a
And,
categorical environment, and apart from that, what I referred in the board, Lordship first up, about the judgment of Madras High Court, where held that since both the parties are agreed, where is the problem of the administrative department to Lordship?
Their stand is that you should get a succession certificate.
Lordship,
Apply one, it's a short one.
Lordship,
It will take you 2 months.
with all respect, Lordship, they are paying for compassionate family pension.
Yes.
And this judgment only just, I am referring, Lordship, same circular where it was challenged, Lordship. Paragraph 7, Lordship, marked portion, Lordship, the 6, it is to be stated that there is no dispute for the relation between the parties. When there is no dispute among them, the authorities cannot dispute the fact and given any other interpretation to the relationship. Only because of that relationship, Lordship, they have imposing that since the two spouses are there, there cannot be any here. In that judgment, Lordship, paragraph 8 also, last paragraph, that the Commissioner Revenue Department there shall scrutinize, sensitize the officials in the order hierarchy Revenue Department about the applicable parts and shall ensure that the merely because there are two ways, the claim of the applicant cannot be rejected without assigning the factual position. In view of the aforesaid discussion, it is clear that the impugned order is liable to be set aside. So my respective submission, I am not on any dispute, Lordship.
A person may have 2 or 3
Yes. Two.
wives. Wives.
Yes.
When he has 2, the possibility of 3 cannot be ruled out. Today, if we give a direction that you process it, tomorrow 3rd person comes up.
Lordship, with all respect, Lordship, they have applied along with an affidavit before the judicial magistrate also. And that apart, they have a PAN card and other card, everything. And children's have birth certificate, Lordship. With all fairness, I am submitting, they are facing a great hardship, Lordship, because the
Respondent,
person.
you are appealing.
When they've challenged a provision of a circular, my lord, where it has been prescribed that, my lord, in case.
We are not interfering with the circular. But is it possible on the basis of the consensus arrived at by all the non-legal heirs for you to process it?
Exactly, Lordship has stated the word known, man. Lordship will see the justification that we have given. Because, my lord, this particular clause has been put to challenge. Lordship will have to see whether we are justified or not.
You are justified in
Yes.
having that.
And in fact, my lord, there is a, my lord, legal remedy available to the petitioner. Approaching this honorable court, my lord, in July 2025, for 1 year, he can wait for this particular order from this honorable court. Instead of, my lord, approaching the civil court. Lordship will see the conduct, my lord, the
Who will-
conduct itself, my lord, cast doubts upon the, my lord, conduct of the petition.
That conduct, Lordship, my landed.
Why for one year, my lord,
Conduct, but
he is
who
waiting?
will pay, Lordship, the entire family's, Lordship, husband expired on 3/12/24. His service is up to 3/1/3/2029. He is not getting single penny. How the family can go for
Oh, he can.
Succession.
Lordship? For
can-
which I pray, Lordship, at
We
least.
will arrange the amicus for them.
Yes.
We can have a look around, we'll arrange an amicus for them.
Lordship,
Hailagan, no.
I am not, my responsible submission, Lordship, at this stage, at least compassionate family pension may consider, Lordship.
For whom? In the name of whom?
Among the legal heirs, Lordship, that is their name and PAN card and Aadhaar card is there. Those who have, Lordship, at least they have some authority, lordship, and also in the judgment of this honorable court in other lordship, also paragraph in larger bench judgment, lordship held that the first and
Which larger bench?
I am just referring this lordship. No.
You've
No.
added that,
Anwar.
this is the notification.
Notification says, my lord, pensioner. Cannot be, my lord, that compassionate family pensioner, that is the term used.
Ah.
It will be issued against one person. It cannot be used for all, against all.
Unless and
They
until,
will distribute it among themselves, my lord, as per their consensus on the issue. This report, my lord, cannot, in fact, the division bench, full bench of the honorable court has held in the situation that they will have to go to a civil court. No.
That
Cannot
not
be-
lordship, but my learned friend, very recent coordinate bench judgment, I am referring lordship. That may not be lordship. Paragraph 21, page 4, lordship. Here also two wives are there, lordships. May I read lordship?
On this issue. On this issue. No. Oh, that is a settled.
No. Yes, since you were saying that how many wives are there, that to be lordship. Purely an administrative revenue authority is to issue that. That is not that part, lordship, regarding that. I am, with all respect, lordship, I am submitting lordship regarding the.
but Mr. Clover, my current counsel, paying for the petitioner also, but Mr. B. General and A. It's the same. Things are completing the matter list again on 16th of June, 2026.
Lordship hearing. Next,
Have a succession certificate, everything settled. Otherwise, we'll decide on the validity of that clause.
lordship.
And
That
we'll stop there.
my response is only on that day, lordship. I shall try to.
Yes. Yes, sir.
Lord, the Panchayat and Rural Development Department was supposed to file an affidavit. But they have filed it not.
What is the issue?
Lord, issue is regard the pensionary claim between two wives, my lord. So my learned friend's petition, my lord, he will submit.
Well, Lord, matter is this, I am the second wife. And there was an joint affidavit sworn in by both the wives that what are the pensionary benefits, they would divide it equally. But later on, they have taken a plea that I was divorced. But actually, as per the judgment of this Daniel Latifi, this type of divorce is not at all acceptable. Moreover, they are differing from time to time. Thirdly, my lord, when there is the order of full bench, any amount of argument,
What is
Cannot-
the order of the full bench?
full bench says that both the wife will get equally.
No. Uniform baby's case, my lord.
Yes.
It says so.
No.
It says
My lord, paragraph 23 is, my lord, may kindly.
No. Let him complete.
kindly para 23. I am reading the para 23. Yes, fine. We also provide that in the event of any such other persons who are entitled to the benefits, that is page 32 of the writ petition. Kindly see para 32 from para 4.
Has
The
it
learned
been
counsel-
disbursed at all?
My-
Has it been disbursed till now?
No,
has
no,
the pension
no
or
party is
other-
getting any benefit now.
Very good. So now, so far as the DCRG and the other amounts are required, are related. Pension rules,
They have got equity.
where
That has been already received by both the parties. Equally.
it has been distributed.
Yeah,
Now the
there is no
compassionate
dispute
family
on that.
pension. Now the compassionate family pension,
Yes,
it will be released to the first wife.
yes.
And if she fails to maintain you thereafter,
Thereafter,
kindly
she
go
will
to the authorities.
she
They
will
will
give
apportion it. Not
50% to second wife.
Why?
Yes,
As of
that-
now, why?
No, that is the full
Yes,
bench
please
judgment.
read.
Kindly see page 32. They, para 23, sub-para 23, we also provide that in the event any such other persons who are entitled to the benefits of family pension in terms of Rule 143 of Pension Rules 1969, including the second or further wives, in a case where parties are governed by the Mohammedan law, are not appropriately maintained by the eldest of surviving widow or wife to whom the pension would be paid. The remedy thereof would be to make a claim for maintenance in the appropriate forum under law and not a claim for a payment of family pension by the state authorities directly to such persons. But however, in a given case, the state authorities on their own volition are of the view that under an acceptable circumstance, the authorities are agreeable or required to pay the pension separately to any such member of a family of a deceased employee, this judgment may not be construed to be an absolute bar on such separate payment. Now there is a joint affidavit filed that.
Which he disputes.
No. How it can dispute? It is a matter of record. Matter of record. Kindly see page 124 of our affidavit in reply.
Why not with the affidavit in opposition? Why not with the writ petition? Why is it come later?
No, that was not earlier. Next. So it is in affidavit in reply, we have filed this. That is of course another matter. But thing is this, kindly see 124 of our reply affidavit.
Now you have seen.
That late Akhtar Jahan, son of late Abdul Kabir, is our legally married husband who passed away on 27/17. During his lifetime, he served under Assam government and survived us as his sole legal heirs. This is true and correct. That in our husband's pensioner details, Kulsum's name has been recorded. Hence, after the death of said late Akhtar Zaman, all arrear amount and pension amount are deposited in the account of Kulsum, that is account number so-and-so, SBI, Koari Mari, branch, Nagang. This is the one. That we, both the parties, come into mutual compromise that in future all deposited amount of arrear and pension would be equally deposited in both Kulsum as SBI Kawai Mari branch, Bhai account number so and Halima Khatun's bank account number so
Yes.
in Kawai Mari. So clear.
Yeah. Now we'll dispose it off.
We think that is because no party is getting anything.
You are saying that you are not party to
And
this affidavit.
my lord, argument cannot overpass the full bench judgment. Full bench judge clearly say, if she first wife willingly does not give, then there is also alternative remedy. But that will prolong the delay. Till then she will not get, I think she will get nothing. I will also get nothing. An agreement, the agreement has value in view of section 273 of CRPC. Of course, nowadays it may be different sections. All right.
Lord, may I draw my lordship attention to the affidavit which they have shown? My lord, on the first page of the affidavit, my lord, only the signature of my learned friend's client, and in the second page, my lord,
No, there is signature of Halima Khatun. Yes, it is there near the stamp.
Because in my page, it is not available. 134.
Page 124. You understand?
What is for my reply affidavit?
My lord.
Huh?
So this is over also. Alibaug. But my lord, in my page, my lord may kindly say there is no signature of Halima Khatun, but in his copy, my lord,
The
it is
photocopy was wrong. Your page photo is larger, so therefore it went out on the border. So first objection
my lord, go.
rejected.
My lord.
Now, next.
Now, my lord, the second issue, whether the rate petition which has been filed, my lord, by my learned friend, my lord, is maintainable or not, because the issue has already been decided by the first round of litigation. Same issue.
First round of litigation.
Yes, my lord, this is a second round of litigation with identical prayer, my lord. WTC 4016-2023 at page 30 of the writ petition.
Understood then.
Then, my lord, this honorable court has held that, my lord, that in view of the paragraph 23 has been recorded, my lord, and the direction is there. My lord, I am just reading the para 6, my lord, just for a clarification, my lord, in view of the above, at page 33, I am reading.
I have read that.
And the aforesaid, the honorable full bench, more particularly the observation made in paragraph 23 quoted above, the writ petition is disposed of, the direction of the honorable full bench would be applicable and allowed in the present case. So now the paragraph 23, my lord, is very clear. Paragraph 23 has said, my lord, that there cannot be any claim, my lord. It is the law which will prevail. Now, my lord, there is a case, we have also said that she had already been divorced and her divorce has already been registered, my lord. My lord, in my affidavit, my lord, may kindly take up. My lord, the annexure 4 at page 85 of my affidavit, my lord. Affidavit in opposition. If my lord may be pleased to find that annexure 4, page 85, column number 4, column number 5, description of divorce, talake bedhi. So, my lord, this is a Quranic form of talaq. So there is no dispute, my lord, and therefore the Assam Muslim Marriage and Divorce Registrar, who is the authority, my lord, under the government of Assam at that relevant period of time, is required to record the registration of divorce in such type of register, my lord. That is the, my lord, register B.
We will not go into the marriage part of it, yes.
Now, my lord, as it has been, it is my respectful submission only to bring into my lordship's kind notice, my lord, that as she has lost the, my lord, the definition of wife after the divorce, my lord, so therefore her consideration of the pension will not come into play, my lord. So that is my another limb of argument. And the lastly, my lord, the paragraph 23, just I am reading, my lord. We also provided in the event any such other persons and who are entitled to the benefit of the family pension in terms of the rule 143 of the pension rules of 1969, including the second or the further wives in a case where the parties are governed by the Mohammedan law are not appropriately maintained by the eldest of the surviving widow or wife to whom the pension would be paid. The remedy thereof would be to make a claim for maintenance in the appropriate forum under the law and not a claim for payment of the family pension by the state authorities directly to such persons. But however, if in a given case, the state authorities on their own volition are of the view that under an acceptable circumstances, the authorities are agreeable or required to pay the pension separately to any such member of a family of a deceased employee, the judgment may not be constituted to be an absolute bar on such separate payment. So, my lord, the authorities, as I am not agreeable, my lord, so therefore the authorities cannot compel me to, my lord, share the payment of the pension to my lord, the writ petitioner, my lord. And, my lord, another, my lord, had been added that she can claim the benefit of, my lord, my lord, the maintenance.
What was your prayer in the earlier round of writ petition?
Same prayer, my lord.
For family pension and
Yes.
for DCRG. That you have got? DCRG part you have got?
Yes,
Whatever you have
we have got.
Now the family pension,
Yes.
already decided in the earlier round of litigation.
Yes,
Tell us why we should
It
consider
is
it again.
decided by the full bench.
Then why should we decide it again?
No, we want that in terms of the order passed by honorable division bench.
Did you make an application to the respondent authority saying that, look, I am not being paid? No. Did you go to the civil court saying that I want maintenance? No.
No. It's more submissions. First thing, the writ petition is maintainable. Because the Honorable Division Writ Court is also 220, that is the writ petition. Follow-up of the writ petition. So that writ petition was dismissed.
No, writ petition, the earlier writ petition was allowed.
For zero necessary case, it was allowed. However, in full bench, it was allowed that it is very much clear. We further hold, para 22. We further hold that family pension being payable.
Just- We will not go here and there, but we are finding it difficult to understand.
Want to
You
divorce?
approach this court by a writ petition.
Yes.
This court says this page 32, full bench will govern,
Yes.
we dispose the writ petition.
Well, that is not fair.
Finished. Now, what is the new ground that I should again pass another order?
No, there is no ground.
Then we dismiss it as a
But
litigant
while
matter
another
and-
is taken a another point that divorce. So Daniel Latif just is clear. This type of divorce is not acceptable.
Very bad. It's a very bad divorce. You are still the second wife. You have the right to right for a maintenance,
Yeah.
and you have a right to pay once the pension is disbursed
Yes.
and she does not maintain you. You can make an application. They are free to give whatever apportionment they want to give. Writ petition
But
does not
here, my lord,
survive in law.
there is an affidavit.
Hmm.
So in their respective account, if the pensions are given, that is easier for them. They are widow, that's why that is my second, and that is a human consideration. Otherwise, in litigation will go, both the parties will suffer.
Human considerations are bound by res judicata and
No, it is agreed by them. An agreement, when it
when
is
was
as
the
per,
agreement?
agreement affidavit.
When was the affidavit
Yes, that is
dated?
affidavit dated 2/2/22.
2/2/22 and the last order by this court was passed on the earlier occasion in 2025 during the subsistence of that particular affidavit.
Yes.
Heard Mr. Ahmed, Emu Mahmood, Learned Counsel appearing for the petitioner also heard Mr. A.R. Bhuyan, Learned Senior Counsel assisted by S. Losco, Learned Counsel appearing for the respondent number 7. Okay. Also heard the Learned Additional General. 4. Okay. The present writ petition has been filed with the following prayers. Okay. Take on the prayer from page number 17. Huh? It is the common case of the parties that the DCRG benefit has been already paid to the entitled parties in pursuance of the earlier orders passed by this court in WPC 4016 of 2023. Full stop. The order dated 2820 or 282024 records that the present petitioner as the second wife in the respondent number, you are respondent number 7 hearing.
I am for respondent 7.
Respondent number 7 herein / respondent number 6 in that petition had staked a claim for the family pension and the DCRG full stop. This court by the order dated 282024 had disposed of the writ petition directing that the case of the petitioner shall be governed by the provisions of paragraph 23 of the Honorable Full Bench as passed in WA number 160 of 2018 within bracket Musammat Junupa Bibi versus Musammat Padma Begum at the rate Padma Bibi. The claim for distribution of family pension between the two contesting parties has already been decided in the earlier round of litigation. On a specific query, the Learned Counsel for the petitioner could not point out any ground on which a fresh adjudication on the claims is required. The Honorable Full Bench in the case of Musaffat Junufa Baby within bracket Supra had held that when a claim is made by the second wife that the first wife is not appropriately maintaining the other entitled members, the remedy thereof would be to make a claim for maintenance in appropriate forum under the law, and not a claim for payment of the family pension by the state authorities directly to such persons. Since this court has already held that the aforesaid paragraph would be applicable to the case of the petitioner, I do not see any reason to differ from the same, except grant liberty to the petitioner hearing to make appropriate pray for relief from the appropriate forum of law for a claim of maintenance and stuff. In the present case, it is admitted that the compassionate family pension is yet to be released to any of the parties, and therefore, at this stage, to assume that a grievance regarding non-maintenance by the receiver of the compassionate family pension with regard to the other entitled members would not be called for, please stop. Would be premature and not be called for, please stop. The Petitioner Advocate General has further submitted that the scheme of the compassionate family pension itself provides for the aggrieved parties who are entitled to a compassionate family pension to approach the department, which has not been done in the present case. Full stop. Accordingly, in my considered opinion, this petition does not survive for adjudication, since the issue has already been adjudicated by an earlier order of this court between the same parties. Full stop. However, the dismissal of this petition in the present form shall not be a bar for the petition number 1 to approach the appropriate forum of law or to make any to raise any grievance before the appropriate authorities in case the compassionate family pensioner fails to maintain any entitled member of the family out of the compassionate family. Dismissed.
Interim order, if any, may kindly.
The interim order, if any, may be vacated. Respondents would be at liberty. The respondent authorities would be at liberty to disburse the compassionate family pension to the entitled pensioner
In accordance with law.
in accordance with law.
Item 26.
Next,
In accordance with law and in terms of full bench.
and in terms of full bench.
As regard item 12, Lordship, has been ordered that come up for hearing, it may be come up for admission hearing.
Item number 12, hearing of admission law.
Much obliged, sorry.
May
Yes,
it please your
yes,
lordships.
Yeah.
Lordship, I am appearing for the UGC in this matter.
Ah,
In my humble submission, on today's board, we have item number 47 to 51 also. And the notification which has been challenged in the instant matter is the same as the notification which has been challenged in that particular batch of writ petitions. And this particular issue has already been settled by your lordships in a previous litigation, WPC 556 of 2024, if your lordship remembers the Singhania University matter.
we held that the PhD
That,
degrees may be
since-
valid so far as those universities are concerned, but so far as for the grant of UGC norms, you must have a PhD according to the UGC norms. If it is not a PhD according to the UGC norms, you will not get the benefit of the UGC regulator.
But
Perhaps you'd like to go through it.
but that man is most probably not applicable in our.
Why?
Because our case is because way back in 2016 we have got the PhD.
Whenever.
And
Please go to the
the
judgment.
same
And they have
was in
clarified
that
also.
case, lordship.
Same.
the UGC has clarified also. RTA reply, man.
Wait,
Yeah, you're also fine.
where is the RTA reply?
Lordship,
That
the
is page
RTI
45, ma'am.
reply simply says that the notification issued by UGC is prospective
Page
in
45,
nature.
In reference to your RTA reply, it informed you the UGC has later dated 16/1/2025 is not applicable the degree already awarded before issuance of the letter dated 16/1/25.
But today, UGC, have you filed affidavits in the other cases?
Lordship, the affidavit has already been notarized.
And
It is
would you
in
like
transit.
to
It is in
respond to this
transit.
particular RTI given by
Lordship,
your officials?
this particular aspect is already there in the affidavit, and the UGC has stated that the degree shall be valid only if the PhD has been done as per the regulations which were prevailing at that point of time when the PhD was done. So it is the same as what your Lordship has held in Tilak Sharma's case.
Would you like to go through the judgment once, sir?
Yeah, I will naturally go.
And then we'll fix it sometime on 18th or 25th of June.
Yes.
Lordship, let it be tagged along with item number 47 to 51. Same notification has been challenged in those
Should we
cases.
fix it along with those items?
Not
sir?
necessarily, because our case is slightly different matter. Because basically they have, UGC have categorically has stated that.
Or Dr. Agarwal, we can do it this way. We'll fix this on the 25th.
Lordship.
In case the other matters are not adjudicated today itself, we'll fix them also on the 25th.
Lordship.
And then when the matters are there, we'll take them up together, but not as tag matters for the convenience
Yes,
of
Lordship.
everyone. Yes.
Yes, Lordship.
This matter again on 25th of June, 2026. Fixed up the learned, Dr. Agarwal, learned counsel appearing for the UGC has referred to the judgment delivered by this court on the judgment you were saying?
Lordship, date I don't remember.
Judgment
In WPC number
number
556 of 2024.
556 of 2024. Full stop. The learned senior counsel has sought for an accommodation to address the court on the on that aspect of the matter. Full stop. You are appealing for with Dr. Agarwal?
No, Lordship.
As does for the Standing Council for Higher Education.
So and so appears for Mr. S. Das, Standing Council Higher Education. Report লিখিব Mr. P. Kotapu, senior counsel assisted by you, Bogua. Huh?
Obliged, Lordship.
47 or 51 color senior that উঠলে একেলগে দেখতে দিও অল্প কিছু
Directed to present status of the, I have received today morning one order to extend extension of suspension period for another 3.
When were you first suspended?
Suspended on my lord, suspension order issued on 10/9/25.
You were arrested
Arrested on 28/25.
28/2025.
Yes.
Okay, 20/8/2025 arrested.
Arrested.
When were you released on bail?
Released on bail 23/8/25.
23. 3 days thereafter. Poxo matter.
Customers.
Then
Sorry, my lord, 23/9.
23/9. And you were placed under suspension on 10/9/2025.
My lord.
After it is,
Suspension order is reviewed on 9/12/25.
just a minute. When after you were released, when did you inform the department that I have been released, sir?
Yes, my lord. I have submitted the application for reinstatement, my lord, on
When?
12/11/25.
12/11/25.
My lord.
Okay, and when was it reviewed?
My lord.
When was it
Reviewed,
reviewed?
my lord, on 9/12/25.
9/12/25, yes.
For
Thereafter,
3 months.
huh?
For 3 months.
So that will be 9/12/25. 3 months would be 9/3.
9/3/26.
9/3/26. Any review on 9/3/26 or before that, sir?
After that, this.
After when this?
And 26 to 2026, my lord, again reviewed, my lord. 26 to 2026.
26.
That was not communicated with the people.
Communication is not necessary if it is there. If the review is there.
3 months, my lord. Then subsequently today morning, I received this, my lord, for another thing. 20 to 20.
No, he said 9/3/26. It was reviewed,
I know.
not 9/3.
90.
9/12/25.
9/12/25. After that, 26 to 26 it was reviewed. And now it is reviewed on 29/5/2026. 26, 90 days gone. Is it gone? No.
On 26/5 to 90 days gone.
How? February has 2 days less.
February.
2 days less. This is 2026.
February, March, April.
February, how many days? Where is the calendar?
He is going to retire from the service on the month 28.
Huh?
28 days, February.
28 days. So please calculate
26, 2026.
what is your ground for, you are asking for what, reinstatement?
My lord,
Why?
my representation is page 25.
Saying what?
My lord, paying for reinstatement in the service, my lord, that is page
That
26.
victim is from your school, alleged victim.
My lord,
Alleged victim from your school.
yes, my lord. I may be reinstated in any another school, my lord.
Teacher, POCSO, school, another school, how does it matter?
Out of district also, my lord.
That is in corruption cases.
Out of district also.
That
another
is in corruption cases.
And charge is yet to be paid, my lord.
Maybe. Mr. B. Talukdar, counsel is for the respondent department has submitted that the petitioner, that the suspension of the petitioner has been reviewed last on 29/5/2026. Prior to that, it was reviewed on 26 to 2026. Full stop. The petitioner, no, the first suspension of the petitioner had come on 10/9/2025, the petitioner was released on bail on 23/9/2025, and therefore, full stop. The petitioner was, the first review was conducted on
9/12/25.
2025, after the petitioner had informed the department of his release on bail on 12/11/2025. Full stop. Therefore, to this court, it does not appear that there has been any delay on the part of the respondents in reviewing the requirement of the suspension of the continued suspension of the petition. To address this court on the other grounds on merits of the petition, list this matter again on the 16th of June 2026.
Public.
Any other ground on merit you give it to us, otherwise on dates? Yes, sir.
Perceive in this case, I have challenged provincialization of one Vikramjit Roy.
And Vikramjit Roy has
Roy.
appeared before this court?
No, he by or judgment, my lord, page 42, relevant portion, page 50.
Without his appearance,
No, his service has been already provincial cancelled.
again cancelled.
Again cancelled.
Then the petition can be closed.
No.
Why?
Here, from the judgment, my lord, the judgment has been passed, setting aside his provincialization and saying direction that my service should be considered for provincialization within 45 days.
It has not been done.
What they have done, order was passed on 9/5/2022. After 45 days, we have filed a contempt. Contempt was continued. In the month of October, 16 October 2025, they have issued my provincialization. Only for 1 month I have served. In November, I have retired. So my case is that I have acquired my right from the date of judgment of this court. So my benefit should be given.
Yes.
I have to take instruction. It was fixed for instruction, madam. I need some time. Another thing, my lord, they have cancelled after this judgment. They have cancelled his provincialization in the month of September 22,
Hmm.
but my service was not.
It requires certain verification to be done, whether you are in the school, whether your certificate is true or not, whether you have got that attendance or not,
But they have
whether a number of
provincialized-
students are there or
They have
not.
provincialized for one
And that
month.
has to come from the school to the block, to the DEO, to the IS, to the,
For their delay, my lord, my case, for their delay,
yes.
I cannot suffer.
File your affidavit when?
2 weeks I'm away.
We are taking assurances very seriously, Mr. Bora.
I am very old person, they already retired, my lord.
Already retired.
Only 10,000 he got from whole life, 1 month service. The order of 2020.
2022, a few months of. But the order was for consideration for
But
provincialization.
this provincialization was set aside.
So,
I am I am about 20 years senior to him. my lord.
on 13th of July, 2026, by which time the respondents, as per the assurance given by their learned standing council, shall file the response. Immediately on the report.
Maybe on in the last
Huh?
June, my lord, 26th or
Not June. We are full up to here,
15th July.
15th July.
And
15th July, report. Yes.
Senior counsel Mr. Esport is on legs. However, Lordship may kindly peruse the previous orders dated 6/5/2026.
6-5.
One of our court asks
Ah,
to regarding my lord, forwarding of
pension proposal. What was done?
16 my lord, we have forwarded to
On 16/5/2026.
2016 my lord, we have forwarded. Like I'm very, as per my Mr. P. That last paragraph. my
Who appears for AG? Huh?
As per my impression, my lord, on 16 my lord, that's a letter my lord. We have forwarded, but account general said that that communication they have not received my lord.
Hmm.
So at this stage, my lord,
The office, Mr. Sharma, learned counsel applying for the accountant general. On behalf of Mr. B. Sharma, has submitted that by a letter dated 24/2/2026, the Deputy Inspector of Schools, Jonai, District Dhemaji, was requested to forward the pension case with all relevant documents routed to the PPG department, elaborating in details the PPO number of the deceased teacher for authorization of family pension payment order in favor of the petitioner. Full stop. A copy of the aforesaid letter has been handed over to Mr. B. Talukdar, Learned Counsel appearing for the Education Department for his onward transmission to the Deputy Inspector of Schools, Jonai, in the district of Dhemaji. Full stop. This matter again on the 15th of July 2026, on which date the Learned Standing Council for the Education Department shall have his instructions from the DI of Schools, Jonai, with regard to the steps taken in person to the letter dated 20/2026. It is provided that in case the family pension proposal has not been forwarded by the DI of Schools, Jonai, in the meantime, till now, the aforesaid authorities shall take appropriate and effective steps to forward such proposal to the Accountant General in the manner requested before the next date of listing. Okay.
May I please, your lordship? My lord, the last page of my writ petition will, my lord, the last page of my writ petition, my lord, will concise the entire matter, my lord. My lord, this is a letter issued on 28th of January 2026. My lord, I have seen that all the name of the district had been mentioned here by excluding the district of Nagaon. Now, my lord, pursuant to this letter, selection in all district appointment is already over. Now, though we have, my lord, come under the merit list and select list, due to non-inclusion in the name of this district in this letter, my lord, we are still waiting for our appointment.
They are amalgamating all Nagaon schools into the other districts.
No, that is not the reason.
Not the reason. What is the reason, madam?
My lord.
Lordship, the department has requested for some time, you know.
Why was Nagaon not included? The decision is already taken.
Lordship, it
There
just,
must be office note, don't include Nagaon. What does that note say?
Lordship, it's just not Nagaon, there are other districts also which,
Which are missing.
yes.
Why?
Okay, that is under examination and they have requested.
Already went missing. Now what to examine?
No, we are already selected also, my lord, by the same process.
Place this matter again on the.
Lordship, may I pray for 3 weeks time?
Oh, yes, on the 22nd of June. Enough time?
22nd.
My lord. My lord, this notice was issued long
You would
back.
have
my lord.
first week, second week, third week. 22nd is beginning of the fourth week. 22nd of June, on which date the respondent shall inform this court the reason for not finalizing the selection process of headmasters in the district of Nagaon. Full stop. It is made clear that in the absence of instructions with the with the counsel for the respondents on the said date, comma, who is the concerned authority?
Will be the director.
Director of Secondary Education shall arrange for a responsible officer in the knowledge who has knowledge of the procedure being applied to be present in the court.
32 and 33.
Obliged.
You are keeping all the schools vacant in charge headmasters. Huh? Full of litigation in the court when select list is available. Yes, sir.
My lord, in this case, lordship, page 59 is the impugn order, my lord. This petitioner, before your lordship, is a my lord, senior, my lord, very honest and sincere, my lord, science graduate teacher of the school. But due to, my lord, the local politics, my lord, in the school, he was made, my lord,
Scapegoat.
absent in a school, my lord.
He was made
Absent in the school on that particular for 1 day, my lord.
1 day, huh?
1 day. In fact, my lord, on that day in the morning, with due, my lord, written permission from the headmistress, then headmistress, he went for toilet, my lord, nearby his house, my lord.
The whole day he was in the toilet.
No. Only, my lord, 45 minutes, my lord.
Why written permission for toilet?
My lord, because, my lord, I have given
The school does not have a proper toilet.
No, my lord.
Where do the children go?
My lord, condition, my lord, lordship, kindly have a look, photograph I have given of my school's toilet, my lord, page 20, my lord.
What all do we have to look
Only
into?
local, he is the, my lord, very.
What all we have to look into?
My lord, you-
Page 20, yes.
Yes, my lord. There, he is very sincere, my lord. Therefore, this school, some teachers, my
Where
lord,
do the children go?
any school, my lord. Yes,
They
my
have to
lord.
answer
This
an
is
HS call?
this is the problem, my lord. Tama, my lord, lordship,
What is your ground of challenge?
my lord, page 39, my lord, lordship, kindly have a look.
Do-
He is, my lord, nowadays, my lord, this is online attendance, my lord, in the portal, my lord.
He gave the attendance.
Yes, my lord. 6 is the serial number, my
Where
lord.
is the written permission from the headmistress?
My lord, this is page, my lord, 18 and lecture 1, my lord. And original part, my lord, page 19.
What does the headmistress say, madam? Permission was granted?
Well, in this case, my lord, regarding WPC number 2263, my lord, we have already.
2260, it is 1228. 1288.
Yes.
Two WPC.
Why two
No,
WPCs?
as per that order, my lord, he was reinstated,
Already-
not to.
Yes, my lord, already.
That is gone.
Stated, my lord.
One
gone.
double eight of 2026.
My lord,
He says I went for 45 minutes to answer nature's call. And you have given me a punishment of withholding my increment
that is
one day,
not available.
1 day and increment for life. Cumulative, non-cumulative?
Cumulative.
Cumulative, up to pension. Major penalty, where is the DP? Any DP drawn?
No, my lord.
Any DP drawn? No. Where is
No,
that
my
order?
lord, my lord, order, my lord, lordship, nothing mentioned, no DP,
Where is the order?
page 59, my lord. No inquiry was also conducted, my lord.
Inquiry was conducted, my lord. Inquiry could be-
But it was not served to me, my lord. The report.
The application has been submitted to the headmaster by the delinquent letter. Who said that? The headmistress is saying that.
Current headmaster submitted one affidavit, my lord, that he was present in the school, my.
On the next step, fixed. We spoke on the understanding council. Secondly, Elementary Education Department shall place before this court the departmental inquiry proceedings held against the petitioner. The reports of the departmental proceedings, held against the petitioner for my original. Please stop. You have filed your affidavit by respondent number 8. Who is respondent number 8?
Respondent number 8, my lord, headmaster.
Yes, headmaster, who appears?
Headmaster, my lord, advocate. He Sohoria, my lord, file, my lord, he is today absent, my lord. We put that all for next item.
Records in original. What is the date? Date to be due. Idea. List again on the 4th of June. You will be able to bring the records in original. Director's order, 4th of June. Have that judgment, give us a judgment that cumulative stoppage of increment with cumulative effect is a major penalty. Punjabi Electricity Board.
Another connected matter is there, my lord.
It's item 33. Another item
Another connected matter, there I.
It may also come along with the, it may,
We are at item
It
number
will-
34. What is your connected item?
33.
33 is connected with the item 32. It comes along with the item 32 on that day.
33 I have already Yeah. Person order listing it for 4th of June.
Obliged.
Yes, sir.
This pertains to registration under the Assam Medical Council
Hmm.
for foreign medical graduate, my lord.
Okay.
There was some issue, my lord, because those who were studying in Ukraine because of COVID and war, some people had to come back and they could not do some of the practical classes.
Hmm.
Thereafter, the regulations say that you have to be sufficiently compensated for those classes by subsequently attending those classes.
Okay.
So my college, my lord, from Ukraine gave a certificate saying that I have compensated those classes. But then as far as I know, initially there was objection because the word sufficiently compensated was not there.
Sufficiently was not there. Achha.
Now, there seems to be a circular subsequently, my lord, which says what is subsequently compensated. It means that I have to attend those classes, which I could not attend physically later on by attending actual physical classes. So the registration was held up and I had to come to the court. As of now,
Initially, we sought for some clarification from the National Medical Commission. It has been received last week, my lord. Now, today, my instruction is that, my lord, the secretary and the chairperson of the Assam Council of Medical Registration, my lord, they are examining the matter, my lord. The next week, the secretary will be out of station, my lord. So I pray for a day, picking the matter on 12th, my lord.
12th of June.
12th of June. By that time, if it can be issued, it will be issued. And
Otherwise,
if
we'll
it cannot be issued, then we'll inform this honorable.
because they have not rejected it also per se till now. So I cannot say that what is the ground for rejection.
Yes, my lord. That is not rejected.
Just because my lord, the livelihood is affected, my lord. She cannot practice without that registration. So she's waiting,
All I can say is another dozen days of
my lord,
vacation.
my lord.
Unpaid vacation, another 12 days. List the matter again on 12th of June 2026. Since Mr. D.P. Baral and its standing council, Health Department has submitted that efforts are on to bring a resolution to the issue involved. Mr. D.K. Patel and a consulting for the National Medical Commission has submitted that the clarifications sought for by the Assam Council of Medical Registration has already been supplied. Mr. B. Pathak has submitted, and the council appearing for the petitioner has submitted that the petitioners are suffering without their registration since they are not able to carry on their profession. Full stop. List on 12th of June as opposite, where on which date an attempt will be made to dispose the petition in the event the resolution is not brought about by the Health Department.
Obligement.
May I please, your lords? My lord, our limited prayer, my lord, within, as per my mandate of the law, suspension orders not yet been reviewed, man. So,
What
we
was
have,
the first date of suspension?
lordship,
When were you first suspended, sir?
my lord,
Were you arrested?
my lord, 11/11/24.
You were arrested.
Yes, my lord.
11/11/2024 arrested.
Yes, my lord.
Okay. When were you suspended?
Suspend 1/12/2025.
1/12/2025 suspended.
Yes, my lord.
When did you inform that you have been released? When were you released on bail?
Effect from 1/12/2025,
No,
lordship.
when were you released on bail?
My lord, 29/11/2024.
29/11/2024 you were released on bail.
Yes, my lord.
When did they know that you were released on bail? Where is the
Suspension issued, lordship, on 1/12/2025, my lord.
where is that order?
Page 67, my lord.
67.
Yes. After 1 year, my lord, this my lord, suspension order has been issued from the date of arrest.
Where is the do you have the report of the DO Dorom?
DO lordship.
DO Dorong report, do you have anywhere?
DO my lord, page 68 my lord.
No, 68 is the charge sheet. In the Department of Proceeding, draft charges.
Draft charges my lord.
Do you have the DO report, madam? Call for the records. Call for the records which led to the imposition of the suspension order of 1/12/2025, number one, and number two. Has it been reviewed? It has not been reviewed till date.
We have not communicated with regard to my lord. So my lord,
List on the 2nd of June 2026, allowing the Learned Standing Council, Education Department, to inform this court as to whether the suspension of the petitioner has been reviewed regarding its continuance.
oblige.
90 days gone, then you'll be reinstated, is it not?
Yes.
Let us see that. Item number 63. Item number. Assistant Inspector of. Yes.
The other day, Lordship had gone through it, Lordship. Lordship, my senior here had also filed an affidavit, Lordship, on behalf of that subsequent to this order, the government did nothing, Lordship. They set over the matter, Lordship. So they had returned to the government, Lordship, page 54. Of the affidavit, Lordship. Lordship may come to para 3.
Yes.
Lordship may remember that the advertisement, subsequent to that advertisement, Lordship, the development had taken place, Lordship. And thereafter, Lordship, this Honorable High Court's order came, Lordship, even the division bench order. Then after that, they have written many times. But the Education Department have not done anything, Lordship. Whether they have not declared anything, whether they have decided to.
The department.
I think it's secondary education, Lordship.
Secondary education, madam, you are not filing her affidavit.
We have not filed our affidavit. Also, the instructions that we have received is that because there will be some amendment to the rules, Your Lord.
Lordship. That will be, and subsequent to this Honorable Supreme Court's order, Lordship. Lordship has seen that in case Prakash Pathak. Lordship has gone through it. What does it say? Lordship, it says that if required, Lordship, they can make further amendment to it, Lordship, and they can continue, Lordship.
Yes, madam.
Because you're the
From
instruction.
2017, people who appeared in your advertisement is there, nothing is put.
So our instruction is that there will be some amendment to the clauses of the rules, Your Lordship, and that is why, and because we were asked to. So that was a submission that was made, because there will be some kind of amendment to the rules, Your Lordship, and that is why we were asked to place the instructions on that, the updated instruction. But till now,
They have not given you any updated instructions.
it is,
They have not
the
taken any
instruction, the
decision.
instruction is that is given is that it is the process of preparation of the draft is going on.
What is the date?
Lordship, it's of the last year.
And this regarding this advertisement, Lordship, what they are going to do, Lordship. That is also required to be answered by them, Lordship.
The issue is liquidation is regarding a recruitment process started in the year 2017. For the post of
2011 also.
2011.
Advertisement is 1711, 2011.
2011. For the post of assistant.
Inspector.
Assistant Inspector of Schools. The writ petition was filed in the year 2023. So the APSC has filed the affidavit in response to the writ petition. The parent department, namely the secondary education department, is yet to respond to the writ petition. Raise this matter again on the 24th of June 2026, by which date the respondent shall ensure the presence of an affidavit in response to the writ petition on record, failing which. Who gives you the instruction?
Mostly the instructions, it has been given by the Department of School Education. By the Secretary, Joint Secretary, Department of School Education.
An office, the secretary in the Department of the School Education shall depute a responsible officer appear before this court to apprise as to why response in the writ petition is not forthcoming. The officer shall also apprise this court on the steps being taken by the Department of School Education with regard to the advertisement which have been initiated in the year 2011. If you have an affidavit in opposition, very good. Otherwise, have one of the officers. Must be Musharraf for this, for this education department.
Your Lord,
Yes, sir.
my lord, the matter, when the matter came up earlier,
Hmm.
then the court, because they were supposed to produce the records. Records are produced by them, but there has to be a verification by the authority concerned. Now, the court said you can also inspect the documents, whether proper verification was carried. There were 2 points. One point was where they were workers as a master role worker. Now there was OM, 5 years continuous service. So there has to be verification. They are no more in service. So there has to be proper verification. The court directed earlier round of litigation, and it should be intimated to the petitioner's concern. Apparently, on the face of it, it is not been intimated. But whether verification properly has been carried out in all different districts, the court said you also, the chance was given, looked into records, but records could not be looked at properly. So at least 2-3 days time should be given. We have talked to the council also other side.
Your Worship, the engaged council is in how the matter at the moment.
The senior counsel is saying that you would require some more time to look into the records.
Where
Perhaps,
On the last date, they've perused the records.
Huh?
On the last date, they've perused the
where were
records.
the records?
But
not
submission
completed.
that it could not be done properly because of paucity of time on a day-to-day basis. We'll have it listed on the, immediately on the reopening.
I'm sorry, man.
Should we have it listed on the reopening, allowing you to go through the documents, or when
No,
do you
it'll
want it?
take about 3-4 days hardly by now.
On the 8th of June,
8th of June.
8th of June?
8th of June. 8th
of June?
Yes, yes.
At Mr. Vidas Ranit, senior counsel, assisted by Learned counsel appearing for the petition of its government. The Learned senior counsel had submitted that the he requires some more time to peruse the record, peruse and verify the records.
Yes.
As for the liberty granted by this court on the
Yes.
occasion, full stop. Accordingly, list the matter on the 8th of August. The Learned counsel for the respondent is requested to cooperate with the Learned counsel for the petitioners to have the records.
8th of June, my lord.
8th of June.
Yes. Not August. 8th of August.
Sorry,
8th
June.
of June.
June.
I'm deeply August.
Number 66, today we have filed my affidavit document. In item 66.
Yes, Mr. Dekar. In one of the items, there is an affidavit.
On yes, reply.
Huh?
On
Reply,
yes. Every case is at file.
Huh.
Only one case reply has.
Reply has been filed. That will cover the other cases also?
Well, because the region, the assigned by the authority lodge is same lordship.
Okay, so one affidavit will,
Yes, ma'am.
the heard Mr. Assessor General Counsel appearing for the
Respondents.
respondents, full stop. And he has submitted that the response to the all these connected petitions has been filed, full stop. Mr. A. Dekal and counsel appearing for the petitioner submits that that a reply has been filed in WPC number. Item number
1825 of 25. Item number 68.
68, item number 68 number.
No.
So in so, and the said affidavit would cover the response of the petitioner in all the other cases also, full stop. Accordingly, list these cases again on
Lordship, item number 66, other council is there, not my claim. In item number 66.
barring item number 66. All the other cases except item number 66, the WPC number is there, full stop. Accordingly, list this matter again on. We'll have it for hearing or admission.
Admission.
Dispose of lordship is small issue lordship.
Okay. We'll have it on the 16th of June,
Yes, sir.
2026.
Apply.
Yes.
In this case,
My lord, I'm sorry for the trouble, my lord. Item 64, there is an interim order.
Interim order in any of the dispositions shall continue.
in this series, your lordship, they have filed their affidavit.
Ah.
Short issue is involved.
Ah.
Your lordship may fix some other day, your lordship.
18th
Because
of
your
June.
lordships can dispose it of your lordship.
18th of June.
Lordship. 18th, your lordship.
18
Lordship.
18th of June. You
Lordship.
filed your affidavit.
Lord.
You
I
filed your
have filed
affidavit.
their affidavit.
The
Reply is not
affidavit filed
required.
by the respondent authorities be traced and placed on record if there is no office objection to the same.
Lords. Deeply obliged.
Wait with the lordship. My lords, on the last occasion, my senior counsel appearing for the respondent had sought for some time to file response to the writ petition, my lord. And today, my lord, I have not yet received any affidavit.
My lord, I could not prepare it. My lord, can you lordship grant us 2 weeks?
Mr. H. Governor Counsel appears for the petitioner. Full stop. Mr. S. Zafar, senior counsel assisted by Mr. S. Shum has submitted that an accommodation of 2 weeks should be required to file the affidavit in opposition. Accordingly, list this matter again on the 24th of June, 2026. The affidavit in opposition, if filed in the meantime, may be replied to by the petitioners. If so.
My lord, 77, 70 similar orders will follow, my lord.
77 and
78, my lord.
78. Na? Kita take it out of it.
Obliged.
Affidavit has been already filed, lordship. Filed today, madam. He filed affidavit.
You have filed your affidavit today. The Mr. Das and the council appearing, Learning Standing Council appearing for the Higher Education Department has submitted that the affidavit in opposition has been filed today. Will sub-register to list this matter again. On anything urgent in the matter?
Yes, lordship, because we are tutor principal, our salary has been stopped. Next.
Salary stopped, okay. On the 12th of June, 2026, along with the affidavit, petitioner may file their response to the affidavit in opposition.
Obliged.
Watching this matter, my lord, they are supposed to file an affidavit, my lord. Date may be given and by then they'll.
Lordship send it for waiting.
The Learned Council appearing for the respondent has submitted that the affidavit is ready and would be filed within the next week. Instead, accordingly, list this matter again on the 19th of June. Instead, the petitioners may file their response to the affidavit if so advised.
This is regarding payment of gratuity, lordship. PWD department, Mr. R. was appearing, so
the response by the respondent is not available on record. Which on a counsel for the petitioner, Ms. Kanangu has submitted that she has not received any copy of the affidavit in opposition. Full stop. Record. So that is what we are saying. We are saying it in a roundabout way. Let's this matter again on the 17th of June, 2026, by which time the respondent shall ensure filing of a response, failing which the concerned, failing which this court would consider imposition of cost matter relates to disbursal of gratuity to the petitioner. Yes, sir, 86.
May I please, Lordship? Lordship, this is matter is regarding pension matter, Lordship.
Which department?
Well, has your lordship taken up
Education.
item 79, my lord?
You are? Who is respondent number 4?
Private respondent.
You are not 79 years. Yes. You are what? Second wife. Child what? Second wife. Huh? Earlier wife expired, then who
First
is
wife was expired.
that? You are the,
I'm the mother of the petitioner.
or you want something from the second wife? You are not sharing anything. You are paying her. You have proof of payment.
Now she is not living with me.
You get us some proof that you are paying something. You are getting the pension because she allowed her son to marry you. Have some compassion. Huh? Otherwise, going there and saying sorry later on won't help. Huh? You have to manage it here.
My lord,
Yes, sir.
I'm
You are
I
appealing
did-
for?
I'm extremely sorry, my lord. Item 47 and 48.
Huh?
Some urgency there.
Huh?
Cannot be taken.
Can
up
it be
next
done in the middle of some other matter going on, sir?
week. Extremely sorry, brother. I think,
Please
my
do
lord,
not, please do not, please do not, because we indulge. There is a certain limit. We will not be
I think it's my lord, what is going right.
expected of him. This matter again on the 22nd of June.
Yes, Lordship.
First of the respondents would be at liberty to file their affidavits, and the petitioner and respondent number 4 would also be at liberty to come to an amicable settlement, if possible. Yes.
All right.
Again?
Please, your lordship. In this matter, respondent number 2 was supposed to file an affidavit.
We have this listed on 19th of June.
Can it be on 12th of June, your lordship?
12th of June. Okay, 12th of June.
Oblige, your lordship.
The 12th of June. Although an assurance was given on the last occasion that the affidavits were being filed during the course of the day, no affidavit is found on record.
In this matter, the review has been filed.
You were supposed to file an affidavit in response. You are filing a review. I don't. How do I know? You gave an assurance to the court. We are filing it within the course of the day. Huh? Paucity of time does not allow the other matters to be taken up. Paucity of time does not allow the matters.
Lordship.
Just a minute. Does not allow the matters to be taken up with the counsel before we file early. Accordingly, list the matters and list this matter again on convenience of the deputy. Yes, sir.
May please, Lord, item number 92, authorized, condemned petition. May I kindly keep fixed on the 12th June
Item number 90.
92.
Yes, sir. You are on the BC.
Lordship, it's regarding item number 43, lordship.
43, some date given? 43? We'll 8/6. It is on the 8th of June, sir.
Lordship, just a slight
We are
submission.
running
It
short
was
of time.
wrong.
We had to rise at 3:15. Can we have the discussion
Lordship.
on 8th? If it is not too
Lordship.
urgent. On 8th.
Lordship.
Yes? Anything else, any urgent matter? We are running short of time.
With regard to item number 98, can it be on Monday, my lord?
Discuss it.
But item 47 and 48.
Ah.
Any confidence then expect?
Lordship, 47 to 51 is connected. Your Lordship had indicated
47
27th
already,
of,
granted the date.
25th of June.
25/6.
25C.
All the dates this side, I will approve.
Item one, lordship, is fixing on any question. I just want.
I reserve the judgment. No, I am not reserving judgments. You will have happy evenings and make it from the motion. Take it from the court. You take a day from the court. Thank you.